May I, Your Lordship?
Yes.
Lordship, I beg to mention item number 28 on behalf of AATRS Nagam. He asked me to adjourn this matter for possible for tomorrow, Your Lordship.
Tomorrow it will be difficult for me, Your Honor, because I'm coming from Guwahati. We have to after 2 weeks then.
Okay, Your
You are
Lordship.
mentioning on behalf of
AATRS Nagam.
He is representing the Deputy Commissioner, who is the most vital party here. So in his absence, of course, we cannot hear the matter. We'll have it after 2 weeks now.
after 2 weeks.
After 2 weeks.
Okay. Miss, made a mention on behalf of Mr. Raresh Navali, additional agent, government, for adjournment of the matter is important. Mr.
B. Pathak.
Now the council is present and has not listened to the prayer for adjournment, provided the date, you want a date. Not yet, after 2 weeks.
After 2 weeks.
Okay. After, so, wait, will come up, this is matter after 2 weeks. Okay.
I beg to mention item number 25.
Item?
Item number 25. Yes, the client.
This is in order, let us see why it has been listed. Okay.
Just for my withdrawal matter. For a withdrawal matter. Withdrawal.
Withdraw.
Yes.
25.
Yes, ma'am.
Okay, it was listed yesterday.
Yes, ma'am.
Okay, Mr.
DR.
Hmm?
DR.
Okay, the other Barrack Council for a petition has an instruction to withdraw this writ petition. One more, government advocate for the state respondent is present and has no opportunity. Putting in the prayer, this writ petition is dismissed on withdrawal.
My lord, I beg to mention item number 18 and 19. My lord, leading counsel is out of station, so.
Okay, this is listed for order. Let us see what it has been listed for. We'll grant adjournment.
Yes, my lord.
Pass message on. Okay. Let us see why it has been listed.
Okay.
Okay.
Yes, ma'am.
Wait for some time.
I beg to mention item number 16 and 17, Lordship. Senior counsel Empertin is out of station, so this matter may be adjourned.
No objection.
No objection.
And Lordship, a fixed date may be given.
When?
Monday.
Next Monday.
Yes.
No problem. Okay. Miss
D. Riba.
Direct counsel for. So that's the D. River advocate. The Dana Senior Council was removed party without discussion and praise for listing this matter on Monday, 28, which Mr.
Pironia.
Dana Council for that respondent has no option. Putting in the prayer with this matter on Monday. Okay.
Much obliged.
Obliged.
By an order dated 4/3/2024, this court has directed the BRO to make the payment of the bill as per the joint verification report. The Lordship will find, my lord, that page 84 is the order. And the relevant portion, Lordship, may come. Page 84, it starts. The operative portion is at page 98. 98, Lordship may come to 90.
24/3.
24/3. 4/3, my lord.
So according to you, there is a pending bill.
Lodge. 24(3), all pending bills, if not paid in the meantime, shall be released in
Where
favor.
have you stated that there is a pending bill?
My lord?
Where have you stated that there is a pending bill?
No, it was adjudicated in the writ petition, so there is no issue. Only thing is that all pending bill, whatever is there, you pay as per the trash is on
Okay,
the.
so according to you, there is a pending bill.
No, now they have cleared. Now they have cleared, but not as per the joint verification report. They have unilaterally decided an amount and they said this is the amount. And now after various correspondence, they are trying to justify that it is as per the joint verification report. But it is not as per the joint verification report. The direction is clear that it should be as per the joint verification.
In terms of joint verification report.
Report. And
Now,
the
as per
exercise.
Joint verification report.
Got you.
So you are still entitled, or there is a pending bill, still there is a pending. bill.
As on today, according to them, they have cleared, but I said, had it been as per the joint verification report, I would have entitled to about 18 CR. Now, what they said, they have given me 3 CR and odd, and saying that this is as per joint verification report.
Now, as per the joint verification, that means it is more than 3 CR.
As per the joint verification report, I have submitted my bill that is more than 18 CR.
Okay, that had not yet been decided.
That has not been decided.
That according to this direction is
It's-
decided.
No, it's a contempt. Since they have not done as per the joint
No, no,
verification
it's
report.
not an admitted amount. Then in that case, it's a
Gotcha.
disputed amount, it appears.
No, trash is on the joint verification of whether this calculation of 3 CR you have done it is as per the joint verification report or not. If they can substantiate before this court that this is as per the joint verification report, the contempt will be automatically dropped. But my clear, my lord, averment and also my lord, the documents to show that it is not as per the joint verification report.
3 CR,
Lodge.
plus CR is.
Lodge.
as per-
It is not as per that.
So, but as per the joint verification report, you are still entitled.
Yes, 18 CR and odd, I am still entitled. So at this stage, my lord, I pray that only notice be issued, my lord.
Mr.
And a PJ cycle.
PG Sarkar, Senior Counsel, assisted by P. Border. P. Border. Counsel for the petition. This is an application filed under section 11 and 12 of the Contempt of Court and 71, read with Article 215 of the Constitution of India and the rules framed under the Guwahati High Court rules. For non-compliance of the order and direction. Where is the order? Order dated?
My lord.
4/3
4/3/2025.
of this code. Dated 4/3/2025. WPC. 3/2024. If you notice. Returnable by 4 weeks. The petitioner shall take steps upon the respondents by the registered post with aiding as well as by user process within a week from today. List is matter after 4 weeks.
Lodge. May I pray for a date on
Date.
26 August?
You have to take steps.
Yes, I'll be taking, my lord.
to-
26th August, my lord.
Okay. Page will come. 26th August. 4 week, will be completed on 26th. Okay. Page will complete this matter on 26th. Okay, sir. Okay.
Yeah, Lordship. Lordship, this is a civil revision petition filed by the petitioner. 226, Article 226, Article 227, read with Section 115 of the Code of Civil Procedure. The revisional petitioner is challenging the legality and validity of the impugned judgment and order dated 5 March 2025 in summary suit number 29/20 in respect of Ding Darang versus Lucky Singh, passed by the learned Civil Judge, Senior Division, East Siang District, Pasighat. Lordship, the case of the revision petitioner is that the petitioner, the respondent herein, filed a summary suit before the learned Civil Judge, Senior Division, Pasighat.
What is
Against
wrong in it?
Lordship.
What is wrong in it?
Lordship, the case is that the legality, challenging the legality is that
It's a final order.
yes, final order. It is final, even its final order, it is for modification. Since the leave to defend and Miss case was filed by the revisional petitioner who is dependent in that summary suit. His leave to defend was not considered.
It was given, it was considered by giving conditional.
Conditional, yes,
Conditional leave.
yes,
So
Lordship.
You have not fulfilled.
Lordship, this is the on the 28th 5/2025, the petitioner on the date of
Deposited amount.
yes, partially I have deposit an amount of 15 lakhs. I could not deposit all the amount because
Then unless you fulfill, how that will.
Lordship, that was my prayer because in that miss case.
No, what's wrong? The civil judge has committed. No,
Because
because he did not fulfill.
my leave application was not considered. Moreover,
Final order, why did not file appeal lies against the final order?
yes, Lordship, that is there, but in this revision petitioner, revision petitioner is seeking for modification and alteration.
How this court can modify and alter?
Lordship, because
Unless the civil judge, the trial court has committed a jurisdictional error. This is revision.
legality, Lordship, my view of understanding that the learned trial court ought to have considered my defense application, and moreover,
It was considered.
partially considered, Lordship, because it was
You did not fulfill.
that was the my prayer because my I am the revisional petitioner who is a business person whose main and machinery his machinery and he is running a
Forget about that because you have been asked to deposit this much of amount,
Lordship.
25 lakhs.
Lordship.
Out of those,
Lordship.
almost 3 crore, 3 CR.
Yes.
And you did not fulfill. It was allowed on the condition that you deposit this amount. You did not.
That is true, Lordship. But my
But
my
what is wrong in it?
my prayer, Lordship, may kindly come to my misapplication. Is page number 20.
Your application was considered.
Yes.
After consideration only, you were given.
Even I have
You were
Lordship.
allowed. You
Yes.
were allowed. Your application was allowed. With the condition that you deposit this 25 lakh, you did not deposit.
Yes, that is true. 25 lakhs.
Asking what is wrong in it? You did not fulfill.
Since I did not fulfill the reason for not fulfillment was itself that in my miss case because
How
my
this court will consider that.
Lordship, I'm running a hardware shop in the Pasighat, which have been seized, forcefully seized.
If you are aggrieved, probably you may have to file appeal, not
Yes.
revision, because revision doesn't lie. There is no defect in the order, and if you are aggrieved by the final judgment, you may file appeal.
Lordship.
Can you see the provision of the revision, civil revision?
Lordship.
Under what circumstances you can file?
Lordship, the jurisdictional
Jurisdiction
alone,
error.
yes.
What is the jurisdiction error here in this case?
But your lordship, legality and
No,
legality.
that's why you, if you are challenging that on that ground, then it has to be appealed.
Yes, lordship. Lordship, the main difficulty was that I have even in the order it is not.
That is why you have grounds. You
Yes.
have a reason due to which you could not fulfill.
Yes.
10 lakhs you could not deposit.
I have deposit 15 lakhs, lordship.
Which you may have. See that we cannot, whether this court can direct the trial court to accept 15 lakhs instead of 25. That cannot be. And if you are, if you have some reasons on that, then you should file appeal.
What's that?
Revision in any case probably will not lie because you have to satisfy the court that there is a jurisdictional error in this case, but which is not. So
My ground is in page number lordship 10. If it is satisfied, then we may. Lordship, ground number 1 is the trial court ought to have considered.
see what to have. This is
Yes. Yes, yes.
This is not connected with
Yes,
this.
yes. The second is the trial court ought to have directed decree holder to allow the instant
This is
petition.
also not connected.
Okay. Third is that the learner ought to have issued a direction to the wherein release all his
Also not
court
connected.
vehicle. 5 is the court will immediately fail to protect the petitioner
This
from
is
petition.
also not connected. See, none of your ground is connected with whether you file appeal instead of converting into appeal.
Also.
You better withdraw and file afresh.
Lordship.
It will be better for you.
I mean, allowed to withdraw, Lordship.
Mr.
Become the.
Planning Council for the petitioner wants to withdraw his civil revision petition with liberty to file afresh after making. With the liberty to file appropriate application. But appropriate application after an asset criteria that is supposed to. This civil revision petition is responding with liberty is breaking.
Deeply obliged.
May I please, sir?
Yes.
My lord, in this case, the petitioners are presently serving as a sub-inspector in the civil police. And I have a very limited prayer in this case, my lord. Basically, my lord, the petitioners are aggrieved by the provisional seniority list of SI, wherein the provisional seniority list of the SI, which was published on 30/9/2024, wherein the direct recruits of 2022 has been placed before me, without considering the fact that the present petitioners were serving as an officiating SI since 2019.
You were serving as
Officiating sub-inspector since 2019, my lord.
2019.
Yes, my lord. But however, my lord, as per the provisional seniority list, my lord, those direct recruits who were appointed in 2022 has been placed before me. If my lord may kindly have page number 55 for a time being.
Yes.
If I may read, my lord.
Mm.
On the basis of
55.
55. On the basis of this recommendation of the DPC held on 22/11/19 and 16/12/19 and subsequent approval of the competent authority, the following assistants of inspector of civil police are hereby promoted and appointed purely on temporary basis until the further orders as sub-inspector against the existing vacancies in civil police in the pay matrix of so-and-so per month, so-and-so, other allowances as admissible from time to time as per the detail mentioned as under. As per this, on the basis of this DPC, my lord, the petitioners were promoted to the post of SI on officiating basis, my lord. The petitioner starts from serial number 13, 15, my lord, 23, serial number 30, my lord, 41, 42, 70, my lord, 84, 101, my lord, 102, 108, and 109, my lord.
What about the others?
Others, my lord, they are not before my lord. Only few countable petitioners are before my lord. Now, thereafter, my lord, again a DPC was held, wherein the names of the petitioners were recommended for regularization of the officiating SI, my lord. And on the basis of the recommendation, my lord, they were regularized on 11/1/2023. If my lord may have page number 68. '68, my lord.
Yeah.
Well, on the basis of the recommendation of DPC held on 11/1/2023, the following sub-inspector officiating of civil police are hereby regularized as sub-inspector against the vacancy of the civil police on the so-and-so other allowances admissible under rules from time to time with effect from 11/1/2023 from the date of the DPC, my lord. Initially, they were appointed as a officiating SI against the existing vacancies in the year 2019. But however, my lord, on 11/1/2023, their officiating promotion has,
19 is from February 2020 only.
my lord, on 11/1/2023, they have been regularized by giving effect from 11/1/2023, my lord. Thereafter, my lord, provisional seniority list was published. If my lord may, for a time being, have page number 75. Page number 75, my lord.
Yeah.
This is the provisional seniority list, my lord. If I'm married, my lord.
Yes.
Consequent upon the appointment of 100 sub-inspector during the year 2022, promotion of 86 assistant sub-inspector to the rank of sub-inspector during the year 2023, superannuation VRS of 4 sub-inspector during the year till September 2024. The final interstate seniority list of sub-inspector in civil police published white order number so and so, dated 11/12/2023 has been reviewed, and a fresh seniority list of sub-inspector civil police is prepared at Annexure A for wide circulation to all concerned sub-inspector. The seniority of sub-inspector from serial number 1 to 57 has already been finalized by aforementioned order, hence no fresh representation will be entertained in their case. The seniority of sub-inspector from serial number 58 to 243 are purely provisional. They may submit their objection regarding fixation of their seniority, if any, with full justification in support of their claim. Objection,
Your name is under
I fall under 58 to 243, my lord.
purely provisional.
My lord.
Okay.
Now, my lord, from serial number 58 to 157 are the seniority list of direct recruits of 2022.
List of
Direct recruits of 2022. From 58 to 157,
157.
my lord.
They are direct recruits.
Direct recruits,
And thereafter only your name comes.
my lord. So thereafter, my lord, since there's a specific averment for raising any objection, if so agreed by the provisional seniority list, I have filed a claims and objection. But as of today, my lord, that claims and objection has neither been disposed of or made any observation to that effect, my lord. If my lord may have page number 91 for a time being.
Very close. Page
91,
91.
my lord.
It was
This is a claims and objection,
submitted on 17.
my lord, 7/10/2024, within a time bound, my lord. So therefore, today, my lord, my only very limited player is for a direction to the respondent authority to consider my claims and objection on its own merit, my lord. Since this has been filed in the year 2024, but as of today, my lord, there is no any observation or any speaking
Disposing of the
my lord,
application.
my lord.
Okay.
That's my limited prayer, my lord.
Yes.
Now this much.
No. Okay. So then
Within a time frame of it.
within the
20 days
period of
from the date of receiving the order.
20 days.
Yes, bro.
Okay.
In deadline, this matter may be disposed of.
Okay. Mr. P.Y. Bhatia.
Yes, sir.
Which is, land counsel for the petitioner. I've also had Mr. S. Tapping, land exchange government advocate for the state respondent. All the state respondents. Okay. Then the detailed order will be passing. The petition will dispose of with the direction to the respondent authority, more particularly respondent number
4.
4.
Or maybe directly,
Okay.
because claimant objection has been brought by the
Okay.
respondent of 4.
To dispose of the
Page 75. AIGP is public.
no, okay. To dispose of the claimant and the claimant objection to provisional seniority list. SI civil police filed by the petition. Within the period of 30 days from the date of receipt of this certified copy, from the date of receipt of the certified copy of this order, okay? The detailed order.
Right.
Yes, okay.
And that particular representation may be mentioned.
Which one?
The representation may be mentioned in the order.
Yes, sir, that's, okay, representation.
Page 91.
Hmm.
Page 91.
Claim filed by the petitioner on 7/10/2020.
Okay.
Deep level.
May I please, Lordship?
Yes.
The petitioner before your Lordship is seeking for a direction to the respondent authority for his release. What happened, Your Honor? The petitioner is presently serving as a senior teacher mathematics at Government Higher Secondary School, Nyafin, since his initial appointment from 2012. It's been 13 years. He is in the same place of posting, Your Lordship. Accordingly, thereafter, Lordship, the transfer order was issued on 13/8/2024 as annexure to page number 24. After 13 years, he has been finally transferred from Nyafin to Government Higher Secondary School, Namsai.
Page?
Page 25, Lordship. 25.
This is the
Transfer order, Lordship.
transfer order.
Yes, Lordship. The following postgraduate teachers are hereby transferred and posted to the places as shown against each in the same capacity and in the same time, scale of pay with immediate effect. And serial number 2 is the petitioner. PGT Mathematics, Government Higher Secondary School, Nyapning, Urumqi District 2, Government Higher Secondary School, Namsai, Namsai District. But Lordship, this transfer order was with a condition. Lordship, down below, terms and conditions. First is regarding first, second, third mob within 10 days. And condition number 2, Lordship, the DDSC principal are directed to release all those transfer teachers from the school as and when guest faculty of same subject join in institution. Or else action will be initiated as per CCS rules 1965 for non-compliance of the government order. It means until and unless reliever is posted, the transferee officer, the teacher should not be released. Because of these conditions, I have not been released. But it's been 9 months, Lordship. The government is not doing anything to post guest faculty of for mathematics subject in my place, Lordship.
It's 11 months.
Yes, Lordship, 11 months.
It was issued in the month of August.
Yes, Lordship.
Now it's July.
Yes,
11 months.
11.
Not yet released. So no
Yes.
incumbent
No,
is
Lordship.
in posted.
Yes, Lordship. That's why I repeatedly approached the principal for my release, but he's saying that since no reliever has been posted against you, so I cannot release you.
So now what is your prayer?
My prayer in Lordship, direction may be issued to the respondent number 1 and 2 to post a reliever against me in my place
and thereafter I may be released from my present place of posting.
Yes.
Lordship, I'm appearing on behalf of Senior Standing Counsel, Tavatagam. Lordship, let notice be issued.
This, you see, I think notice, you want a notice
Notice
issue.
today notice.
Can be disposed of. Have you filed any representation thereafter? Yes, you have also filed representation before the principal.
Yes, I have filed.
Principal has also.
Principal also forwarded, yes, Lordship.
And then,
May I have leave?
okay,
But with a condition that the pendency of this writ petition shall not bar the authority for posting guest faculty in my place, my reliever. That small observation may be made. Let's see what action they are initiating for posting my reliever laws.
Mr. Taylor, Land Counsel for the petitioner. By filing this writ petition under 226 of the Constitution of India, the petitioner seeks direction to the respondent authority to post guest faculty for mathematics subjects at government higher secondary school, Nyapi, Rukume district, as a reliever of the petition. And thereafter, to enable the respondent number, who is the DDSC, who is to release the principal?
Principal for.
To enable the respondent number 4
Yes, Lord.
to release the petitioner from the said school
In terms of transfer.
in terms of the transfer and posting over the date 13/8/2024. The case with the petitioner is that although by an order dated 13/8/2024, he has been transferred from GSS Nyapin, Kurumkume district to GSS Namsai district. With the condition that the DDSC principal shall release the transferred teacher from the school as and when guest faculty of the same subject join the institution. However, the petitioner has not yet been, however, although 11 months has passed since then, the petitioner has not yet been released due to non-posting of the reliever in the non-posting of the guest faculty stroke reliever at GSS Nyapin. Issue notice. Returnable by followers. Stop. Mr.
Titato.
Land Council appeared and accepted notice appearing on behalf of Mr. Titagum. Land Steering Council
For
Education Department appeared and accepts notice on behalf of the respondent number
All the,
How many?
all the respondent.
All the respondent.
Yes,
One is state.
yes, one is commissioner.
Okay, commissioners, okay. All the respondent. All the respondent. No formal notice. Therefore, no formal notice need be issued to the said respondent. However, the petitioner shall furnish extra, the requisite extra copies to the land council appearing on behalf of the respondent during the course of the week's staff. List the matter after 4 weeks. Okay.
And that is small observation.
Okay, so, okay, it is made clear that pendency of this petition shall not be filed on the, not be filed for
Not bar the respondent authorities.
not by the respondent authority to respondent authority
For posting of my reliever lordship.
for posting of reliever, no, guest faculty.
Yes, faculty.
At GSS Nyampi, and to release the petitioner from the same school.
Yes, yes. Deeply obliged, lords.
Obliged, Lordship.
Total delegate.
May I, Lordship? Lordship, the brief fact of the case is Arunachal Pradesh Staff Selection Board. They issued public advertisement inviting application from the eligible candidate for filling up of 316 non-ministerial technical staffs. And out of 316 posts, I'm agreed by 28 posts advertised for the pharmacist allopathy. Since I have done my mastery in pharmacy, I am qualified for the post of pharmacist allopathy. So pursuant to that advertisement, I applied for the said post, and I was issued admit card. My documents were verified. Subsequently, I have been allowed to participate in the written examination. I was selected in the provisional shortlist because my category scheme was only stage 1 scheme only. My post of pharmacy was only selected only after written examination. There was no viva voice and other criteria. So after written examination, I was selected. I have been shortlisted. However, in the final selection list, my name was not included. But subsequently,
there was no viva.
No viva, because it was in the scheme only. There were two type of scheme. One was stage 1 only. Mine was stage 1. After written examination, the selection process would be, because the APSSB shall recommend for appointment to the recruiting agent department. And other schemes were there, which like driver, police, and other posts that followed viva and other tests. But for pharmacist allopathy, there was only a single stage, that is written examination. So I was after publication of the final selection list, when I obtained the marks, I secured highest mark in the written examination, but my name was not included in the final selection list. So agreed by that, I have submitted series of representation before the APSSB, but same is not yet considered. This is the Could I invite my lordship to page number 30? The advertised post for the pharmacist was 28. Out of 28, they
Page.
recommended
Where is?
page 30 is my master of pharmacy.
Where is that advertisement?
Advertisement is page 43 onward.
Just a minute. Huh? Okay, the requirement is degree.
Requirement in the advertisement, it is diploma. However, after the publication of this advertisement, the Arunachal Pradesh Pharmacist Council, they submitted memorandum before the PSSB, even to the Director of Health Service, saying that most of the candidates who applied for the post are degree and a master degree holder. Therefore, that has been considered, and there is no dispute on that in terms of degree. 44 is the 44 last second, pharmacist allopathy. Last second is 28 post. 23 post was reserved for APST. 5 page number 44. Last second. 24 by 24 is the code number. 23 reserved for APST. 5 for UR, that's unreserved. I fall under unreserved category.
Okay. So in the selection, there are unreserved members also who are selected.
Yes, yeah, only one has been selected out of 5 unreserved. Unreserved, in fact, the unreserved is unreserved. There is no reservation.
So only one.
Only one has been selected.
Okay, and then your mark is more than only one
Yes,
selected.
the highest mark as per this impune result notification is 155.5. However, I secured 159.5. That I'll show, my lord.
And page number 51 is the continuation of advertisement. Page number 51.
Yes,
Lordship, scheme of examination 3.
yes.
Stage. Here, assistant technician, field publicity assistant, and pharmacist allopathy is in second last. Page number 51 is stage 1 only. Therefore, those who falls under stage 1, they go for written examination only. So this is the scheme of examination.
Assistant technical and technician.
Yes. These all categories, they fall under stage 1. So there was no Viva voice and other tests with respect to these posts. And Lordship, page 61. This is a continuation of advertisement. These are the syllabus that was prescribed, which I studied.
No, let us come back to the advertisement.
Yes.
Where is that the advertisement requiring the qualification? Prescribed, what is the prescribed qualification?
Page 50.
Okay, where is the qualification?
Post code 24/24,
Hmm.
pharmacist allopathy, educational and other qualification, class 12 science passed from a recognized institution, board with diploma in pharmacy, D firm, from any institution, board recognized by Pharmacy Council of India, and must be registered under the Arunachal Pradesh Pharmacy Council, India Pharmacy Council.
Okay, let us see your qualification.
My qualification is from 30 is my master degree.
Okay.
And 31 is Bachelor of Pharmaceutical Technology. Higher degree was not the dispute.
Okay.
So,
and you have registered?
Pursuant to this, I have applied for the post, and the APSSB issued admit card, e-admit card, bearing roll number.
No.
The application is in 6667, page number 6667.
So whether you have registered under the Arunachal Pradesh Pharmacy?
Yes, I have registered.
Where is that?
Page 40. I enrolled, and the validity is till 31st December 2025.
Okay,
This-
where is
This is the certificate of registration, page 40.
okay, where was the scheme that you have just shown? Where is the scheme of the examination where the Viva is not required?
The page in the advertisement, page 51.
Scheme of examination, and yours?
My falls under postcode 2424. Postcode in 3, scheme of 3, stage 1, 2, 4 is for constable empty driver. Head constable stage 1, 2, 3, 4. Driver HMB and driver this stage 1 and 3. And assistant technician, field publicity assistant, these all that falls pharmacist allopathy 24/24. This is stage 1 only.
Stage one
Yes,
only.
only.
What is the stage one?
Stage one is the person, the candidate who applied for this post, against this post, they'll go only for written examination.
Where do we see that?
That is not here. That is not specifically mentioned here, but that was the practice. And this is not in dispute because all selected candidates, they were selected after written examination.
Okay. Where is the result?
The provisional result is, it starts from page 70, result notification.
Okay. And your case?
And 76 is the 76 are the selected candidates for pharmacist allopathy, and mine is 1001143. First one for
100.
1001143.
Where do we find that?
The first one. Pharmacist
Page
page 76.
76. One zero zero double 143.
Yes.
Post 424 pharmacist. This is selected.
This is result notification after written examination. This result notification was published, wherein against 28 posts, 33 candidates were selected.
Okay, this is 33.
33.
So
Wherein my I found my roll number is included in the select list.
okay, thereafter
The document verification was conducted on 17/02/2025 at page number 78.
document verification.
Yes, wherein I have given all my documents, right from mark sheet, master degree, entire certificate. However, as per need, they have taken the document required.
This is your this is the remarks on the verification of the
Yes.
document against you.
Against me.
Okay, what is this TRC? Permanent, okay. Okay,
These are the documents that I have submitted. And after receipt,
okay.
there was no any communication, and this deemed to be construed as accepted. Page 78.
Okay, thereafter,
And thereafter,
Final
page
result.
79 onward is the final result notification.
and your category?
And your lordship, page number 798.
Yes.
Page number 98, final result of postcode 2024-24 pharmacist allopathy. First is Tenjin Sampel Sermu. He is APST. He has secured 155. Lordship may find in total marks. Column total marks 155.5. And serial number 3 is the only non-APST who comes under unreserved quota, UR. And they are all selected on merit. This has been published on merit order.
And
he has secured 150.5. The one who has been selected under general category.
150. Okay.
150. And lordship, 100 is there. 100 down below. It is marked as one APST vacant post could not be filled due to unavailability of eligible candidates. Wait list could not be maintained due to unavailability of eligible candidates.
APST vacant post.
Now the post was 28. They have selected 27 posts. Citing one post could not be filled up because of ineligible candidate.
Where do we find your mark obtained by?
That also. Then thereafter, on 25/3/2025, APSSB, they have published one notification citing that the candidate can download their mark sheet from the web portal. And page number 103 is my mark. The marks of
103 is your mark sheet.
Yes.
Total mark?
Total mark is 159.5. 87.5 I secured in common paper, and in my technical paper I secured 72. That comes 159.5, which is the highest among the selected candidates.
This is 87 is out of?
Out of 100, and 72 is out of 100. 200 mark was the aggregate total mark for this examination. And I have downloaded my answer sheet also. Answer sheet is
Okay.
continuation. And then
Let us see your prayer.
my prayer is, Lordship, to include petitioner's name in the impugned final select list. Pursuant to the written examination held on 07/12/2024, and directing the APSSB to recommend my name for appointment.
Yes.
This is a notice no issue.
So there is interim prayer.
Interim process, this is it can't be considered because result notification is of 28 February 2025. APSS must have already recommended to the department, and it seems since the private respondent 4 is there also. One private party has been.
Private respondent is non-tribal candidate.
No, he is APSC candidate. However, he has been placed as rank 1.
No. How he can be? If you are rank 1, then he can be in the rank 2.
Therefore,
Why
I
you
have
made party?
therefore I have arrayed him as party.
No. If you are agreed, then you should be agreed by this 3.
Three-
Number 3, who is not
Three
against?
is he is supposed to fill up against the serial number
Three.
3, who has not been implemented as a party here.
He is the one whom you should make party, but not the one.
Not the one.
One is APST.
APST only.
He will remain as a 2, 3, whatever maybe, but
Lordship-
your name will be placed above that. He is not
Lordship, the
party.
ground for making him as party is because
Then in that case, you have to make all these as a party.
Lordship, the APSSB has published the
No, he
result
is
in
highest
order,
among the APST.
in order of merit. They have published the
No,
result in
the
order
number
of.
1 cannot be kept blank in that case.
Therefore, I have made number 1 as party.
No, that cannot be.
The last has to go.
The
not
last
the
has to
first.
go, not the first, not the first.
Not the first.
The ground is because I am the highest mark, because I have secured.
No, you are not. Okay. Then in that case, you see, the last one.
The last has to go, even if we go by his argument.
Such a party. Because the second last will go to last, and then you will be in the first, according to you, isn't it?
No, Lordship, according to me.
No, this.
If,
No. You have to say.
No,
wait,
correct.
wait.
Lordship, my prayer is by prayer number 1 is
This is
by
the wrong calculation. Planning council is the wrong calculation.
Lordship by is
No, you have to pause and think.
in that case, Lordship, I'll strike out private respondent.
You have to decide whom to make party. If you are agree by the last one, make the last one as the party, or you agree by the non-APST, because if the non-APST, because non-APST probably this, if there is only one, then this has to.
He has already
and
occupied.
Yes.
So
So
No. Lordship, it is in the advertisement. There was 5 posts for the
no,
general
this-
category.
not 5 posts. Unreserved,
No, unreserved was 5 posts. Why?
All of them should come within the 5 only.
Yes,
Then only.
yes. However, the result notification was in order of merit. In order of because
Then
he has been placed at serial number 3. Had that been the position,
then he will be supposing if you are placed in serial number 1, in that case, then he will be placed at serial number 4. But then you have to make party to the last one. The last one.
Last will be, they will be affected. They have to strike off.
Last one is going to be affected if you are being.
No, he will not strike off because there is 28 posts. 1 post has been left vacant.
Okay.
27 posts.
Then
has
you
been
don't
filled
have to
up.
make party. So you are claiming the 1 post vacant post.
Yes, 1 post vacant. Because since then, Your Lordship, may I complete the argument?
Yes.
So that then I went to APSSB saying that I ought to have been selected because I am the person who secured highest mark in the examination. APSSB, in fact, they have not given me any logical answer. However, they said your certificate seems to be not in order because the wording is something different. Bachelor of Pharmaceutical Technology, it is written.
Okay, that difficulties.
So then they directed me to meet the Director Health Service. Director Health, I went to Director Health Service. Director Health Service, they have written to the Arunachal Pradesh Pharmacy Council. Arunachal, again, Arunachal Pradesh Pharmacy Council, they have written letter to the university from where I have obtained the degree. Then university, they have clarified that these are the synonymous posts, and they have given the PCA Pharmacy Council of India's affiliation.
This was submitted for the authority.
Yes, I have submitted to the authority. That's my prayer is if the representation may also be considered.
Okay, so this certificate, the clarification has, that means not yet. Okay, you have submitted the clarification letter
Yes.
by way of submitting
Yes.
representation.
Yes.
Which is still pending.
Yes.
That has not yet been considered. Then in that case, in the meantime.
I think now I'm getting, actually copy was not served in advance. Now his submission is okay. The made one, he has to be made as a party. This correctly he has been made. But if this is state lordship appointment if already made, then there's no questions of keeping.
Okay. Mr.
Arkoyu.
Only notice has to be issued.
Arkoyu, Land Council for the petitioner.
Because 5 posts for unreserved lawsuit, those have been already filled up lawsuit. By now they have been already given appointment lawsuit. So interim, I think this is said that may not be required lawsuit. Notice may be issued.
Lordship, if the interim is not considered, then again subsequent, if in case of subsequent advertisement, then
226 of the Constitution of India, the petitioner has challenged the final impugn order is at
Page 79 is the final result. Final notification where the petitioner's name is not there.
The final result dated 28/2/2025 issued by the Arunachal Pradesh Staff Selection Board, Vidanagar, in respect of the, where is your concern? The final result of post code 24/24 within bracket pharmacist within bracket allopathy bracket close and another big bracket close. You submitted that although the petitioner has secured 159.5 in the state examination, which is the highest of all the candidates. His name he has not been selected. His name has not been included in the select list for the under the postcode 24/24, pharmacist allocated. The petitioner has also submitted when you have submitted representation?
Presentation on 27,
On 27,
27/03/2025.
2025. Where is that? Where is that?
It's on page 100.
106.
Oh, sorry, 106.
106.
Annex 12. Series of representation. I have.
Praying for reconsideration for selection of the pharmacist allocated under postcode 24/24 under advertisement number, advertisement dated 17/7/2024, which is pending disposal.
And Lordship, after receipt of the clarification from the university, I have submitted another representation at page number 106, 16/04/2020.
Representation dated 20. And on when?
16/04/2025, page 106. 04/2025.
16/4/2025. Where is page?
116, last page.
Then representation dated, this and earlier and this dated for consideration, right? That will come. Okay, issue notice. Returnable by 4 weeks. When returnable by
4 weeks.
4 weeks. Okay. Means Mr. Estapin, Lion Senate Government Application. Accept notice on behalf of respondent number 1
and 2.
1 and 2. And Mr. Mr.
3.
For the respondent number 3 and 4, no formal notice need be issued to the respondent. However, the petitioner. No, you are for 3 and?
He's
three.
He's for 3 only.
Okay, 3, 3.
4 is the private.
So 4 is a necessary party.
Here, Lordship, now I'm getting, because copy was just now I haven't served, Lordship. Here, Lordship, as per his submission, Lordship, there are 5 unreserved posts, Lordship.
No, so even if 5 unreserved posts also, he cannot be made as a party.
Then
because he's in any case, he's at the top of the trial.
What I'm saying,
he can become only second if the present petition application succeeds.
Lordship, what I'm submitting is, Lordship, 5 unreserved posts, Lordship. 5 have been already filled up, Lordship. Suppose if he has to be accommodated, Lordship, he will be entered in as a pass, even as a pass. The last has to go, Lordship, from the unreserved category, Lordship, who is not party in this case, Lordship. Fifth among the unreserved, because on merit they have been selected against the unreserved post, Lordship, though APST, Lordship. There are 5 unreserved posts, Lordship. On merit, APSC candidates have been selected for this on merit, Lordship. But this 5th one is not party in this present petition, Lordship.
Now probably
because these unreserved posts have been already filled up, 5 posts.
Because this, if he succeeds, his name automatically as per the mark shown, would be placed at the top.
Then last has
and
to
then
go.
the last number, which is 20.
Last among the unreserved posts.
No, if his name is placed at the top, then it will come down only.
Down only.
No, it will come down, but then since one post not being filled up due to non-availability of the qualified candidate, probably none of them was there in the present case.
Yes.
And probably this party also is not required. Because he is the top. among the APST.
Yes.
He cannot be. In any case, he will not go.
Yes.
Even the fourth also will not, fourth or the fifth also will not go.
No, because they will be shifted to the APST
Yes.
category.
They will shift to the
That-
APST category.
That is correct.
That is what. So
Only the merit position will be changed.
probably,
Only the merit position will be changed.
yes, only the
Their
position will
merit
change.
position will be
So
affected.
Probably this, you have to strike off this name.
Lost.
Okay, Mr. Koyu, non-council for petition, some is that. The respondent number 4 is not a necessary party with the petition, therefore pray for striking of his name from the post item. Then you, in that case, you have to file. Okay, this is to be removed. Okay. The prayer is allowed. The registry shall do the legal. Okay. Please this matter after 4 weeks.
Also, I am praying
Okay,
for the
okay.
interim because
Okay, in the meantime, in the meanwhile, the.
One difficulty is there also.
The only will say that no bar disposing,
The representation.
disposing the representation.
No.
Okay.
no, Lordship, in
In
the
the meanwhile,
interim, if
there
not
shall be
filled
no
up,
bar.
I'll not pray for, if already filled up, then I'll not pray for this. This will automatically go. If not filled up, because one post is
Not yet filled up, not yet
not
filled
yet
up.
filled up,
The
because
order itself.
Lordship, what will happen is, if in case the requiring agency, if the subsequent advertisement for the pharmacist post is called for, then
Meanwhile,
this will
the.
become impartial
No
only.
bar, the bar on respondent in disposing of the 2 representations submitted by the petitioner on the date, both they give. When was it? 2 represented. 27, 3, 2025 and 16, 4, 2025. Prima facie, it appears that the petitioner has scored the highest mark, and then there is one which is lying vacant. And probably,
Lordship, he cannot claim against the post reserved for the APST.
no, not
The
that.
post left is the APST only. Lordship. One post is not filled up. This is not
Now-
for the
now-
unreserved also.
Because specifically this direction may not be possible at the moment. Okay,
Okay.
let them file.
Because he can claim against the unreserved post only.
This is matter. Okay.
Of like this.
Yes. And for respondent matter, respondent 2 and 4 matter, in both the case matter. And for the respondent matter. No one appears. For the petitioner also. Mr. You are for respondent 2 and 5, my lord, in both the case. Okay, Miss Sangita. Land government advocate is present on behalf of the state respondent number 1 and Mr. El Parne.
1, 3, and 4.
You are 1, 3, and 4, huh? And Mr. El Parne for 2 and 5, madam. 5. In absence of the petitioner, matter standing here, this is matter after. Where is the office? Whether you have filed affidavit? Yes, madam, we have already done. State also?
Yes, sir.
Okay. No, 2 and 5, you have for 2 and 5,
No.
already filed.
Valid.
Office not said not yet filed. Okay. And some is that they have already filed affidavit. Okay. Leave that. In absence of the, the matter is standing from, this matter after 3 weeks.
Number 8.
Okay. You have not yet filed. You are for the petition.
Yes.
But not yet filed.
Yes, Your Lordship.
fine.
Affidavit on behalf of 4 and 5, we have filed, Your Lordship, already.
Filed.
Yes, Your Lordship. For 1, 2, and 3, yet to file.
Yet to file.
Yes, we'll need some time, Your Lordship.
Mr. Ta, you are for respondent number?
6, 7, and 8.
Have you filed?
Yes. Otherwise, please over admit and fix for hearing.
Affidavit of land management.
Not yet filed.
Land management.
Okay. So how long it will take
Yes, Your Lordship.
for file? Your land manager, okay, it's not you.
Land management is, we're representing it now.
You are
Before they,
representing.
yes.
Okay, then
Yes.
you'll be
There
filing.
was a, yes, standing council. Now we are representing. Your
Okay.
Lordship. I'll be filing.
So how much time you require?
3 weeks, Your Lordship.
Okay. You are Miss?
Please.
Hmm? You are a counsel for the petitioner. Your name is there?
Yes,
C.
Your
Bansi, you are a counsel for the petitioner is present. Miss. Is Sangeeta. You are a government advocate. Praise for father, 3 weeks time to file affidavit on behalf of, well, the summits that earlier, the standing council represented the respondent number?
1, 2, and 3.
No, the land management is respondent.
Land management is 1, 2, and 3, Your Lordship.
Okay, 1, 2, and 3. Now. She represents the respondent number 1, 2, and 3, and prays for some time. But prays for 3 weeks time to file affidavit, on behalf of the respondent number 1, 2, and 3. So, Mr. Jikara, Land Council for the respondent number
6, 7, and 8.
6, 7, and 8 is also present. Is paid for by Ms. Sangeeta. List is, okay, the Ms. Sangeeta is granted for the 3 weeks time to file affidavit on behalf of respondent number 1, 2, and 3. So, in view of the law, list is matter after 3 weeks.
Problem.
Item number 9.
Your Lordship, the senior counsel is engaged in court number 1. Item may be passed over.
Respondent have not yet filed
Yes.
affidavit notification.
In item number 9, we have already filed.
Okay, then you have filed. So who is respondent number 3?
3 is the district land revenue and settlement officer.
District land revenue, who will represent now? Land revenue government now. Who represent earlier?
Earlier, Mr. Pandu.
Okay, standing council
Standing
representative.
council.
Now you will be representing.
Yes.
Okay, so
Then
So
I
finish up
think
now?
for 1 and 2, we have to,
you have already filed.
no, we have to file.
Okay,
Because for 3, we have already filed.
yes, yes,
Earlier, we appear for 3 doses and we have filed.
okay. Mr.
P. Ronia on behalf of Mr. Tara.
Okay. Lana Council, here on behalf of Mr. Tititara. Oh, Mr. L. D. Lloyd. Or
No,
Tititara.
on behalf of Mr. Tara. T. Tara.
Tititara, Lana Council for the petitioner. Stop. Mr. Estapa. Lana Senior Government Advocate. Sam is said. Although they have filed affidavit on behalf of respondent number
3 has been filed.
and 3 and 5. But now since they are represented, the respondent number 1, 2, and 4 also. Okay. No, there is no 5.
There's no 5.
Yes.
1 and 3, 1 and 4 also.
1 and 4.
4, 3 we have already
have
filed. 4, 3 we have already filed. Okay.
So 4, 3 you have already filed?
Already filed.
Okay, although they have filed, they have filed affidavit on behalf of the respondent number 3.
3.
Now, since they are representing respondent number 1, 2, and 4 also.
Let's say 3, the affidavit filed by respondent number 3 will cover the respondent number
Okay,
2.
no,
2 also.
then you are not filing them.
2 also.
Okay.
Because deputy commissioner and assistant deputy, they are
Okay,
in the same
okay.
body.
And then
The affidavit of 3 will cover the respondent number 2 also.
Okay.
And for 1 and 3, 1 and 4, I'll be filing it.
Okay. It submits that the affidavit for respondent number 2, the affidavit filed by the respondent number 3 will cover for respondent number 2 also. However, wait for some time to file affidavit on behalf affidavit in opposition on behalf of respondent number 1, 4.
Yes.
1 and 4. The prayer is allowed. This is matter after 3 weeks.
Yes.
Right.
Okay.
My lord, in this case, the last occasion, my lord, the state was given time to file affidavit. My lord, your lordship will can. State is there, I'm not saying.
Ma'am, please. Especially in this item number 10 is
16.6, my lord.
One is.
Guys are repeated reminders, they have not provided any instructions.
So what to do?
The role of the collector is very clear. We'll go on the reports. As per the
Go by the record.
In this reading.
Not filing. Then the matter, can this matter be then?
Yes.
Admitted and listed for hearing?
yes, item number 10. Item number 10.
So,
My lord,
can this matter be
the
listed for?
question, my lord, the limited question here.
Okay.
That will not be on the ground of limitation, that was, my lord, the authority rejected. They said it will not accept the reference because it is time barred. Now, my lord, the role of the collector is basically mainly dependent section, your lordship will kindly see, section.
What is
64.
this matter about? Just a minute, huh?
Item number 10 is
I'm on 10, my lord, not 11. 11 is.
11 is
It is with 11 also.
Yes, yes. My lord, basically the issue ultimately will be, my lord, boiled down to, my lord, because the award was under the earlier act, my lord, that is the Act of 1894.
Just a minute.
Now, here, my lord, in the present case, the issue is that, my lord, whether the reference was within time or not, my lord.
So. This CRP, by this CRP, we challenge the order passed by
yes, by the
District judge.
reference authority.
District judge.
Reference authority.
Reference. Who is reference authority?
Alok. May I just take to the impugned order. Impugned order is in page
Reference authority is district
244.
judge.
244. 244, District and Session GS West Coming. It's a reference case number 244. May I just read? Basically, we are challenging this. CRP. If Lordship is ready to hear the matter, then I can argue special of item number 10. Item number 10 is related to this impugn order, which was dismissed by the reference authority. The case was, application was filed before a deputy commissioner, and deputy commissioner has referred this application to the reference authority, but then reference authority dismissed the matter on the ground of this delay, and that is another ground. Another ground is insufficiency ground. So I may just take to that particular ground. The relevant, I can read the relevant portion. May I just start from the beginning? Is a page 244. 244.
244.
Yes. First, I will go to the impugn order.
It starts from where?
Sorry, I'll start from 244 only.
244.
So in fact, this item number 10 can be disposed of because this pleading is complete.
Okay, whether the record is necessary, records of the trial court, whether it was called necessary or not.
I think
necessary.
it's your lordship may see if necessary, then you can call, otherwise it can be disposed of.
No, what I'm asking, whether it was it called for? Whether record was called for?
No, record was not called.
It is not necessary for the.
Not necessary, I think. It
Not
can
necessary.
everything can be known from the records. It's clearly reflected even in the
Okay, let us see what is the impugn order.
yes, 244. May I just read the whole reference that order.
Okay.
241, may I just read reference application dated.
No, just a minute, yeah. So you briefly state what is the case about, thereafter read the.
Sorry?
Briefly state.
Okay,
The-
basically what happened, your lordship, this is a project that is called Tato Hydro Power Electric Project of 700 megawatts. So this project was to be acquired by the Reliance company, I think it's back. There were the two notification. One notification was in 2009, second notification was in 2010. And it was supposed to be acquired for the
Is okay, yes, two.
yes, there was two notification. One notification in 2009 and another notification was in 2010. Total area of 318.49 hectares was supposed to be acquired for the Tato second hydropower electric project. Now, after this notification, the award was prepared. First award was prepared. Is in page 108, but I will just prepare. After the award, what happened that land was not acquired by the Reliance company. Now, what happened? Not acquired by Reliance company, but an award was made in
Award for what?
first award for the compensation.
Not acquired, but award.
It was acquired, award was prepared, but then compensation was not paid to the beneficiaries. Now, what happened in 2003? This respondents, the NEPCO, they came into being. They wanted to take that, they wanted to start that project.
Earlier it was Reliance.
Yes,
Earlier it was Reliance.
earlier it was Reliance.
Now
The
Nico,
government and NAPCO has signed the MOU on 12/8/2023.
whatever Reliance then.
Reliance is nowhere. Reliance has left.
Okay.
Reliance has left. And 12/08/2023, the award was the MOU was signed between this government and the NAPCO. Now, what they have decided is that award is already in 2012. So they again gone through the award and they prepared the award as per the LARA Act of 2013. That is the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. So under that, there is many components. One is the market value. Second is the solution, multiplication, relief and rehabilitation. The 5-6 components are there. The government has approved. And then now they disburse the compensation amount in the month of May of 2024. Now some of the petitioners, they file a protest petition saying that, okay, the award was in 2012, but then award has been re-prepared as per 2013. But then in compensation award, they have not calculated as per the market rate of as per 2013. So it has to be the latest the market rate. Now in this case, what happened? Some of the petition, after filing the protest petition, they file a reference application before the Deputy Commissioner. Now there is 2 reference application. One is reference application 02/2024, which the reference authority has passed the order in favor of the petitioners, landowners, saying that land has to be acquired with the market rate, solution, and all the components which are entitled under LARA Act. That is been passed by the reference court. But before that, when the application was filed, the reference application that is important is 02/2024. When a reference application was filed, there were total 79 applicants. So including the present petitioners. So what happened was, in that reference application 02/2024, that was represented by power of attorney holders. But then some of these petitioners, the present petitioners in this civil revision petitions, around 8 petitioners out of 79 petitioners, they came to know that their name also been in that reference application 02/2024. No, they have decided is that we have not signed the wakalatnama, we have not signed the power of attorney. So they have decided to withdraw that application, saying that we want to withdraw the application from the fresh application. That is categorically stated in the miscase application, and concerned reference court has allowed that application. In that application, in the order, it clearly mentioned that they wanted to file independently, and also in that misapplication, it was said that they should be struck out. It is clearly mentioned. I will come to that. Now, what happened after withdrawal from this reference 02/2024? We filed fresh application, reference application after 2 months. After 2 months, we file a fresh application before the reference authority. Now, reference authority has taken a different stand, saying that you have your applications are delayed. Whereas our same application, we went together in with the reference 02. The reference authority has entertained and has passed. We also enclosed the judgment in this civil revision petition. In that judgment also, it clearly mentioned that this 8 applicant's name was struck out from that reference application. Now what happened is the reference authority has rejected our application, saying that there is a delay. Whereas we were applicant in reference application number 2, and it was allowed by reference authority, saying that they wanted to file independently, and we filed it independently. So there is no delay. That is one. Another is that reference authority should not decide the delay, because as per section 64, my understanding is that Deputy Commissioner Collector has the authority to decide whether this application has to be sent to the reference authority or not. That has to be decided by the Deputy Commissioner.
So the application has to file before the Deputy Commissioner.
Yes, we have.
And the Deputy Commissioner will forward it to the
Reference authority.
reference authority is district judge.
Yes. Then our application was rejected on the ground. I will just go to that judgments. How they have not entertained. How on the what ground it has been rejected.
So there is a provision that the reference authority cannot reject on the delay.
Because
It's only the Deputy Commissioner who can.
yes, because section 64 clearly.
Is there any clear provision to that effect?
That effect, Lara, I could not find out.
Then-
But then Deputy Commissioner has the power to extend this up to the 6 months or 1 year.
Whether the Deputy Commissioner has extended in the present case?
That's how our application has been forwarded to the reference court.
Okay, so without considering that, he cannot forward it, that means.
Yes. They
After
cannot.
considering that only. if
That
he
only
accept, then only he will.
he will refer to a reference authority. Yes.
Is there any provision to that effect?
Yes. Section 64. I will just read section 64. I will just come to section 64. Your Lordship may see the section 64. I will read that section 64. Now, another question your Lordship has to see is that when the reference authority can accept the application of a reference application 0 number 2, same situation, only our difference is that we strike out from that reference application. That is one. Another is that we file reference application after 2 months before the same reference authority.
Say that you initially withdrawn 2 months back.
Yes.
At the time of withdrawal, whether there was a liberty.
Liberty, basically in order itself, I will just,
Corrected to you.
yes, I will just read. That is they are on the ground, but then I will just read to that one. May I just see 231 of my civil review petition. I'll just see our prayers and then what is the ground, and then come to the order. 231. Is our application, miscase application for striking out, and our ground is there. I'll just take to our ground and the prayers. So I will just take to 238. In our misapplication, we have what we have said. I will just read only two ground. 238.
Yes.
Yes, may I read that too. That the applicant did not sign any wakalatnama following Sri such and such to file the reference on this behalf. So that's one. Second ground is that a signature of applicant has been fraudulently used for manufacturing the illegal irrevocable power of attorney, but the fact is that applicant does not authorize any individual to represent him. So this was the ground we have taken, that we should, and then I will just come to the prayer. Prayer is, you'll also may see the prayer, 214. 240.
Yeah.
Yes, may I read that one? Number 2. allowing the withdrawal of his name from the list of the petitioners in the reference case number 02 to 24 with a liberty to file afresh if so warranted or advised in stage or past orders are deemed fit proper by the honorable in this interest of justice.
What is the order?
So this was our prayer, and I will just take to my order. Is Miss case is page 228. Our order is into. I will read this whole order, also. 228. To merit. Merit from the third paragraph. In the meantime, Miss case application number such and such 18, 19, 20, 21, 22, 23, 24, 25 in reference case number 02 to 24 have been filed by the petitioner beneficiaries. We are the number 2, 3, 30, 23, 26, 27, 34, 43 in the reference number 02. With a prayer to strike out their names from the reference case number 02 to 2024 to the Land Council or Mr. Ingo, the Council has submitted that aforesaid application number such and such did not execute the power of attorney with the present petitioner. Therefore, their name may be struck out from the list of the applicant with liberty to file afresh. There's one. So now see, second, Land Council for applicant has no objection. Your Lordship may see that, but that's important. No objection to strike out from the applicant in the order to pursue their case independently. That's one. Second is also important. Land Council for respondent number 1 to 2 has no objection, my lord. No objections. That's why our prayer and no objections. Heard the parties. Since there is no objection to strike out petition number such and such from the present case, I am inclined to strike out them from their reference application. Accordingly, such and such are disposed of. Next date is fixed for the main reference code. That is the 24 written statement by respondent. This is for. So this was the case, my lord. So there is the respondent has no objection. It was allowed. Your Lordship was also the concerned reference code also has recorded that they wanted to file independently. Accordingly, he allowed the strike out the applications. Miscus application from the reference number 2. Yeah, so now after this, we file the reference applications. After that, we file a reference application. Yes.
Before the deputy commissioner?
Deputy commissioner, yes.
Okay, then.
And deputy commissioner has referred the application to the reference authority. So I will just come to that.
And after this,
I'll just come to the application.
And in that reference application, this impugn order was passed.
Yes, right.
Okay.
Yes. So I will just come to the application 104.
Yes.
104. So you'll also may see this one. Subject forward 104. Yes. Subject forwarding of application for enhancement of a compensation amount in respect of land and other attached rates for the construction of Tato 2 hydropower Xiaomi. With reference to above mentioned subject, and applications received from C such and such council for the landowners pertaining to acquire land for the construction of Tato 2 such and such application along with annexures are for application along with annexures with details for here with all the self-explanatory. This is for kind information necessary, and this was forwarded to the reference authority. So now after that, the matter was listed on 18. I will just take to that impugn order. The impugn order is in page 200 for 244. Yeah. So here also it's clearly mentioned when it was received, when it was forwarded. It's in page 244. I will just read first paragraph. Reference application dated 30/09/2024 is received from DC Xiaomi forwarding the application dated 16/09/2024 filed by Land Council for Landowners, such as on behalf of 12 landowners is received by this court on 17/10/2024 with a petition addressing this court annexures in the said application having various annexures therein. Third paragraph, I have seen the forwarding application, however, the CCUMA has not sent it. But this is the problem about the collectors. It's not a problem of the applicants. It is mentioned, the CCUMA has not sent it with comments in terms under section 65(1)(2) of the act mandated under law. That is one ground.
What is this 65(1)?
Sorry? Yes, 65(1). Yes, 65(1). I will just read that 65(1). 65(1) is a collector's statement to authority. One, I will just read. In making the reference, the collector shall state for the information of the authorities writing under his hand A, B, C, D. May I read that one? 65. A is a situation and extent of the land with the particulars of any trees, buildings, standing crops thereon. B, the names of the persons whom he has reason to think interested in the such land. C, the amount award for the damages and paid or rendered under section 13, the amount of compensation awarded under the provisions of this act. D, the amount paid or deposited under any other provisions of this act. The E, if the objections to the amount of the compensation, the ground on which the amount of compensation was determined. That is number subclause 1. And subclause 2, the statement under subsection 1 shall be attached a schedule giving the particulars of notice served upon and of the statement in writing made or delivered by person interested respectively. So this is section 64 and 65.
My lord, just a minute, I'm interpreting. My lord is taking up the matter for final hearing or for admission?
No, just I don't.
I understand, well, to understand.
Okay, so now, today, so why this impure order?
So relevant
18/10/2020, 18/10, no? 18/10/2024 is the impugn order.
Okay. So.
(248) is the ground. I might just read 248.
So this petition, your petition suffer from the defect.
May I also read from 247, second paragraph, the impugn that order.
Yes, yes.
Upon perusal of application data such and such number, receipt is obtained by the petitioner. No receipt is obtained by the petitioner. However, it is submitted that it was submitted through the mail at office of DCCUMA, but such documents of mail report is submitted. Even after reading together about the petition data such and such are found to be insufficiency in narrating the ground required under section 64 of the Act. 64 of the Act, besides no comment made by DC under section 64, which is also found inadequate. Next paragraph, it is also noted that since the award or the compensation were given to the applicants in the month of March, April 2024, application data such and such is found to be filed after 4 months, 2 weeks from now. Question here is, now they can entertain the application of others. Now, in our case, the time has to be seen and the ground is made before dismissal. For 2 weeks from date of the LLS application dated. However, provision section 64 that required to be filed within 6 weeks from the date of collector's award. Next paragraph, a suit has been numbered as a reference case number 06/2024. Land Council filed the application without order of the court to file the same, but the established process is that. So it is completely unknown. Also, I'm not able to understand the ground. If you see this, reference is received, the same is listed for hearing on the motion stage, and order of the court only application is to be filed before the court and affidavit, but the applicant has filed without a speaking order, hence the same cannot be taken into account the stage except the reference application dated by CME, hence application filed a petition is dismissed on technical ground. So dismissal is on technical ground. And view of the above observation, the petition suffered from the following defects. 1. For the want of comment for DCC Yomi under section 65 of the Act. 2. For the reason that application the section dated 22 did not have an acknowledgement to receive or supported documents of mailing it as a claim by the Land Council. 3. The reason that application dated 1669 does not have a proper explanation as mandated under section 64 of the Act. 64 of the Act and explain reason delay in preparing the reference and any disclosure of previous application dated and such. For the reason that application for reference is filed on 16/9 after lapse of 6 months from the date of passing of the award, payment of the compensation in the month of March 2024. And normally payment should not have been made in the month of 2024 as the code of conduct was enforced in 17/3. Thereby, application is part of the law of limitation, and the application has failed to explain the application that is 16/09/2024. Explaining the reason for seeking delay of filing 16/09 is here in 6 months. However, applicant has no explanation that it was paid on 16/09. So, for the want of explanation, therefore, the suit is rejected and dismissed accordingly. So this is the ground. So my lord, this application is was dismissed on a technical ground. Now referring many things, but then
now what is to be done today according to you? What is to be done today?
My lord, if you are insisting, my lord can admit the matter. My lord, we have raised the question of maintenance to the petition. My lord will kindly consider that so far the other case is concerned that is arising out of the same, my lord, acquisition proceeding. Now, my lord, in that award has been made, we have challenged that award because we say that, my lord, the Act of 1894 is applicable, not the Act of, my lord, the 2013 is applicable. And, my lord, there is a apex court decision and our High Court decision on that point very specifically. The section 24, 1A and 1B that has been decided. So, my lord, we are raising that question also, that even section 64, they are seeking a reference under section 64.
You are responding in item 10 also?
I am 2, my lord, respondent 2.
Respondent number 2, item 10 also. Okay.
10. Because, my lord, we are not party there, my lord, because no notice was issued. But in the revision petition, we have been made party. We have filed an affidavit also. We have challenged on various grounds. One is also that this CRP is not maintainable. Secondly, my lord, we say that once you have not given the liberty to file a phrase, my lord, this without any, my lord, in the second the liberty was given, in the first liberty was not given.
In this case?
Yes, my lord. So, my lord, they could not have been, even the, my lord, the application could not have been entertained. Question of deciding the limitation is different. Now, my lord, your lordship will kindly see section 64. The collector has been given the power to give it. My lord, the collector is like a post office, my lord. He will just receive it and he will send it. Like section 11 in the Arbitration Act, my lord, your lordship, when passes order under section 11, my lord, your lordship says that since you are arbitrarily appointed, arbitrator will decide everything. Now, my lord, the authority has a power to decide whether the application was made within time or not. But I am, yes, my lord. So it is, yes, whether it within time or not.
This is judge will decide. No, the deputy commissioner.
No.
Okay.
So
now here in this case, commissioner, this
so, my lord, what I am submitting, my lord, my submission, my lord, subject to what my friend says. My lord, in that case, the entire matter has been decided. Earlier, they were party to it, my lord.
Which case?
In 11, they were party initially in the reference court. But they said that the fraud has been committed and all that. Their signatures, they have not given the wakalatnama and all those.
They have withdrawn from this 11.
Withdrawn.
From item 11, you have withdrawn.
Not item 11, my lord, in the award, my lord, not here. In the award court. In the reference court.
In the reference.
They may not withdraw.
Okay.
And no liberty was given to them to file a phrase. But still then, your lordship will decide the matter. But what I am submitting at this stage, that my lord, matter may be admitted.
Okay.
Subject to the maintainability and other things, my lord, that we kept open. And my lord, your lordship will hear the matter.
Okay. We'll fix then list to be listed for hearing. Okay.
And
I think
Section 73 of the Act says that once an award is made in some other cases, even they have not, my lord, preferred an application to refer the matter, my lord, they can get the same benefit. They can approach the, my lord, collector. Yeah.
Sunil Babu, non-counsel for the petition meeting. And we also have. So,
He's appearing for respondent number 1.
okay, so can we admit it? Okay. Mr.
Only question of maintainability will be kept up.
And Ratan. Oh. And Ratan, additional IG. For respondent number?
I am appearing for 2, my lord. Nipco.
1. Collector.
1 is collector. My friend is appearing.
Okay.
Lord, my name has been shown on the last occasion wrongly, my lord. K. Agarwal, man.
And K. Agarwal.
K. Agarwal.
K. Agarwal.
Yes.
Non-senior counsel.
Assisted by Mr. Senapati.
Assisted by Mr. Senapati.
D. Senapati.
Counsel for the respondent number 2.
अब क्या चाहते हैं इसको रुके हुए होने से अच्छा रहेगा तो 19 or 20 August.
That means the petition list is that for hearing after?
No, 20 मतलब 20th of August. 20 August. 20th of August.
20.
My lord admitted, my lord.
Yes.
My lord, lordship will kindly see subject to the, my lord, issue of maintainability.
Subject to?
Because if your lordship don't
admitted, subject to the?
My lord, the answer of maintainability.
Subject to?
Issue of maintainability.
Okay. The issue of maintainability is kept open. List is matter for hearing on August
20, madam.
20. Okay, 20 August for hearing. Okay.
All right. No, 11 is there. 11 is there, madam. 11 I am appearing for the appellant. Well, on the last occasion, my lord, they said that they have filed an application before the before us, my lord.
In 11, you are for the?
I am for the appellant.
Appellant.
Nipco.
Okay.
My lord, your lordship will kindly see the last part. My lord, Mr. Agarwal, learned senior counsel submits. My lord, that has been some, my lord, typographical error, my lord. In fact, Mr. Pathak made the submission. Your lordship may clarify this in this order.
So, you are reading order?
16.6, my lord.
Okay.
16.6, so and so, assisted by so and so, my lord. The second, since the parties are only duly represented by the respective counsel, and the records have also released the matter for admission hearing on ITNA. In fact, my lord, this matter is already admitted.
Okay.
In the
Already
meantime,
admitted.
Huh? This is admitted.
Earlier. In the meantime, the undertaking given by Mr. Leonard Counsel for the so and so and so and so shall continue till then. That has to be extended. Mr. Agarwal, Leonard Senior Counsel, submits that the rest to settle name has been wrongly probably written. It should have been Mr. Pathak, my lord. That my lord, your lordship will clarify this. Otherwise, my lord, it will be little difficult.
They are the appellants, I am the respondent.
So, submit the respondents are willing to settle the matter out of court, then the application has to be effectively submitted before the appellant. In this regard, Mr. Agarwal, Leonard Senior Counsel, for the appellant, so his junior shall obtain necessary instruction on the next date fixed. My lord, in fact, that application has been received by the authority concerned. Now, my lord, they have to, my lord, this is a matter, my lord, it's a more than 300-400 crores of money is involved. Now, matter has to go step by step to the higher authority. So it will take little time. So, my lord, since the other matter is fixed on 20th, let this matter be also fixed on 20th.
Okay.
In the meantime, let's see, my lord, if I get any instruction on that or not. And my lord, your lordship will make clarification to that effect that it is not me, my lord, Mr. Pathak has made the and the extension of, my lord, the undertaking that has to be done.
Yes. But so far as the extension is concerned, one difficulty is slowly creeping in is that there's no express day of the proceedings of execution till now. Now the executing court is asking us because like executing court has to now give a report as per the apex court direction that every 6 months, in fact, the execution proceedings should be closed, and if not, there has to be a report. So something concrete, hopefully in the next that comes out.
But actually, what happened when this earlier order was passed, my lord, this honorable court was, my lord, trying to pass an interim order. My friend says that he will not proceed there. So accordingly, he gave an undertaking. That undertaking is going on.
Mr. A. Agarwal, Lance Senior Counsel. Assisted by Mr. D. Senapati, Lance Counsel for the applicant, is present. Mr. D. Pathak, Lance Counsel for the respondent number 1271. And Mr. And Ratan, Janet Additional AG for the state respondent number 72 are also present. Staff. So this undertaking shall continue.
Undertaking will continue, and my lord, the matter may be fixed on 20th.
20th.
In the meantime,
Since the connected matters are fixed on 20, as prayed for come by parties, let this matter also be listed on 20 August 2025. Stop. In the meantime, the undertaking given by Mr. Parker, Direct Counsel for the respondent number 1271 on 7/5/2025 and extended on 16/6/2025 shall continue till then. Start. There is a typographical error in the order dated 16/6/2025, where Mr. Agarwal, Lance Senior Counsel, where
should be Mr. Pathak instead of Mr.
my
Agarwal
lord,
in the last second paragraph.
just make a clarification. Nothing is required, my lord. From next para it is clear, my lord, but your lordship will just give a clarification in your lordship's order, my lord. That though in
the paragraph 4 of the order dated 16/6/2023, the name of Mr. Agarwal, Lance Senior Counsel, has been mentioned instead of Mr. Pathak, who submits that the respondents are willing to settle the matter out of court, and that the application to this effect has been submitted before the applicants on 26/5/2025 shall stand corrected as Mr. Pathak. In place of Mr. Agarwal. So, page grade for list this matter on
20th.
20th August. Okay. Well,
The respondents are yet to appear. Service to the respondent is complete and they are yet to appear.
Who are the other respondents? How many respondents are there?
Two respondents. Two respondents also.
Okay, the report is regarding both for two respondents.
Two. One, two, three. Or five respondents.
What about the other respondent?
All service to the all of the respondents are completed.
Mr.
Yes, Your Honor.
Yes.
Yeah.
Land Council for the petitioner is present. The office note dated 20/01, 2025 and 27/2/2025 reflect that the notice upon the respondent number 1, 2, 3, 4 and 5 has been duly served. So the judicial magistrate first class concern. Okay. When no one appears on behalf of the respondent. Now what to do? Whether record was called for?
Record.
No,
no, sir.
Record was not for. Record is necessary. In view of the above, the notice upon the respondents, upon all the respondents are complete. Whether in this case, for the purpose of disposal, whether the record of the trial court record is necessary, you are challenging what?
Trial court.
Whether the record would be necessary for the adjudication of the case. Mr. Ira? Tell me, record is necessary? Mr. Ira, that counsel for the petitioner, some mistakes. Trial court record would be necessary for the purpose of for proper adjudication of the petition. Call for the scanned copy of the trial court record. So this matter after 3 weeks. Okay.
I will now. May I please, Lords?
Yes.
Item number 13. Pleadings are over. In item number 13, pleadings are over. It is ready for admission hearing. However, in item number connected with petition, item number 14.
13 is ready for?
My lord, admission hearing. But however, my lord, the connected matter is item number 14, my lord. In that case, I have directed to take a dusty service upon private respondent number 5. And I have
Directed to?
my lord. Item number
In 14, you are directed to?
take a dusty service upon.
Okay, have you taken?
Yes, ma'am. I've taken. I have filed my return affidavit also.
Affidavit also?
Yes, ma'am.
So whether the respondents are present?
Lordship, senior standing counsel is out of station due to health issue.
So you are representing respondent number 5?
No, Lordship, 1 and 2.
1 and 2,
One and
Health
not the
department.
5.
What for 5? He is representing 1 and 2.
1 and 2, health department.
May I take your lordship to my affidavit? Dusty affidavit. Return.
Item
14.
14.
Yes. Page 15. And this is the my lord.
Page 50?
Yes, ma'am. 50. My lord, it was duly received by one David Chetri, who is the staff of this private respondent number 5, my lord. And there is seal also. My lord, otherwise, let this man of service be deemed served. And it may be fixed for admission hearing and some other day.
In item 14?
Yes, ma'am. 14.
Mr. Etlampo, Land Council for the petitioner, who submits that after closing service upon the respondent number 5 by way of justice service, he has filed affidavit to that effect. This is your affidavit?
Yes, ma'am. My affidavit.
50.
Page 50 is my lord, that acknowledging this.
Okay. Your affidavit is?
Affidavit is. That's the affidavit.
That's the affidavit from. Okay. Okay. In the compliance affidavit and also the acknowledgement of the notice by this David Chetri is
office staff of respondent number 5.
The office staff of the respondent. Acknowledged and signed by the office staff of the respondent. Staff. No one appears on behalf of the respondent. So just a minute. In view of the above, the notice is deemed to have served upon the respondent number 5. However, no one appears on behalf of the respondent number 5. Okay, Mr.
T. Tato.
Land Council appearing on behalf of the respondent number
1 and 2.
1 and 2.
I will be appearing for 3 and 4.
Okay. 3 and 4. Submits that his senior is out of station, therefore pray for adjournment.
Yes, Lord.
Of the matter. Mr. N. Ratan Naran, additional AG, appear on behalf of the respondent number 3 and 4. Okay. Since the parties are being duly represented, let the matter be listed for admission hearing after 3 weeks. Okay. This order will cover the item number 13 also?
Yes.
Yes.
Okay.
13 and 4.
List, the item number 13 will be listed with item number.
Okay.
All right.
This is 14th. This is matter along the item number 13. Okay.
Ma'am.
Yes.
This is.
Yes.
This is second regular second appeal, madam. Appeal again, the order passed by the learned court below in appeal case, madam. So, madam, what if any in this case, the initially complaint was lodged before the village authorities, madam. And in the village authorities, madam, the proceedings was held on which, madam, the respondent, madam, flatly refused to appear before the learned, madam, the village authorities, madam. Customary court now, as per the, madam, the civil code act.
The respondent refused to appear before the village authority.
Yes, madam.
Okay, then the
Then
order was passed.
Then
against him.
order was, yes, madam, village authority
By
passed.
impugn order.
Yes, no, madam. Order was passed by the village authority.
Okay, by
Against
village
that
authority.
order, they prepared an appeal before the civil court, madam. Seniority.
The respondent.
Respondent, madam.
Okay.
And in the civil court, madam, the civil court has passed an order by which, madam, everything has been, madam, violated, madam. By perverse order has been passed. Madam, there is a, madam, substantial question of law is involved in this matter. The substantial question of law is, madam, learned court below, while passing the, madam, the impugn order, has totally in disregards of the, madam, the provisions as contemplated under the AFR, madam, firstly. And secondly, madam, some issues which has not been at all raised by the, madam, the petitioner, appellant here in respondent, madam. Then that has been also decided, madam. So against that, madam, if lordship see, then, madam, the order passed by the learned court below is totally in violation of the, madam, the provisions, madam, the AFR, madam.
What the provision says?
Provision
regarding the
says, madam,
actions?
madam, when provision says, madam, there is a, madam, provisions for the village, madam, village authorities, madam. The village authority has every right to, madam, decide the case. Madam, the plenary power has been conferred upon to the village authorities, madam, under the AFR, madam. Beyond any limits, madam, without any limits, madam, the village authority can decide, madam. Now, madam, as per the findings of the learned court below, which I have been viewed in this.
No, so you say that before the village authority, the respondent refused to accept,
appear. Someone was issued, plainly he refused to appear before the village authority, saying that no, don't issue any notice, don't issue any summon, I am not going to appear in your court.
There was filed in written application?
Yes, madam.
Okay, so what is the legal, what the provision says regarding this? If the respondent refused to appear before the village authority,
Madam, of
whether
course,
can it proceed?
as per the madam, the provisions, madam, of course, there is a mentions that in presence, decision has to be passed in open darbar.
Open darbar in
presence of the parties.
Yes.
Along with the,
Then how the village authority can proceed in absence of the respondent when he refused to appear before the village authority?
No, madam, ultimately, madam, the refused to appear is one thing, madam. Why, madam, the village authority is a customary court, madam?
Because he don't want to participate in the, before the
His the respondent discretionary will not applicable, madam.
No, that is why I'm saying, where is the provision?
There is no provision, it's just, my lord, that he is not.
But then how the respondent can be compelled?
My lord, compelled to appear before, my lord, the village authorities, my lord, as I pointed out, village authority is a
Unless there
customary
is a
court.
specific provision saying that in absence of the respondent also, the matter can proceed.
My lord,
ex parte.
by new amendment, my lord, this
Yes,
is the,
this is the provision.
this is the before the amendment, my lord. Before the amendment, my lord, and before the amendment, my lord, there is no provisions for the ex parte order, my lord, ex parte proceedings.
Yes, yes.
Now, my lord, after
This was decided, when this was decided?
Of course, my lord, before the amendment, my lord.
Okay, then.
Then, my lord, my lord, irony is, my lord, when my lord, the respondent is not, my lord, when he refused to appear, my lord.
No, that is why I'm saying, if there is no specific provision to proceed ex parte in absence of the respondent.
Ex parte, therefore, my lord, we are raising the issues.
There, as per the earlier, before amendment, if the person refuse, then it cannot be compelled.
My lord, when there is a complaint, has to appear, my lord.
But he, no, this is
On
regarding,
which, my lord,
regarding what matter?
If my lord peruse the, my lord, the plain letter of the respondent, my lord, then my lord.
Forget about letter. The provision, letter, whatever may, okay, of course.
And there is also no, there is also, my lord, no provision. My lord, rather parties, there is also no provisions that he has to refuse, my lord.
No, but
when the person is, both the parties are indigenous to the state of our.
Can decide, but then provided both participate.
board has to participate,
Yes.
my lord, when the other party is refused to appear, my lord,
So
ultimately
suppose
has,
if, without refusal, if he doesn't appear, then in that case,
my lord,
no refusal, but then did not appear. In that case, will the KEBA proceed ex
my
parte?
lord, the very scheme of the appearance of the parties is to represent in the process proceedings,
So
without
here-
giving an opportunity.
Here in this case, the respondent remain absent.
Yes.
Now in that case,
No, my lord, when,
there is no provision
my
to
lord,
proceed ex parte.
my lord, very idea and the very underlying principles of the, my lord, the proceeding ex parte is, when the other party is, my lord, refuse to absent, my lord, refuse to participate, then in that case, my lord, ultimately, as a court, has to pass, my lord. Ultimately, as a court, has to pass the
Pass
decision.
what ex parte proceeding or saying that the other party don't want to
Other
participate.
giving
so
an
that he cannot
opportunity,
proceed.
giving an opportunity is such things that so as to afford him opportunity, afford him such opportunity. Malad, the opportunity has to be given, Malad, ultimately. But that opportunity, when the such person is refused to appear, Malad, that opportunity has been exhausted, Malad. The very idea of the opportunity, say suppose if the today proceeding is held before this honorable court, if the other party is not appear without maybe some other reason, without intimating this honorable court, that yes, he may be having some personal difficulties, and he may be having some the other domestic problem. Then in such case, Malad, giving opportunity is one thing, Malad. The one opportunity has to be afforded, given, has to be given, Malad. But in such case, he knowing willfully, refused to appear is Malad, amounting to Malad the contempt.
No, see, she apprehends that she is not going to get justice before the local authority. If there is an alternate remedy where she can or he can go before
Malad,
the
alternative
judicial-
remedy will be, Malad, may kindly appreciate one thing. The alternative remedy will be, first of all, if she filed an applications before the such court, then such
No,
Malad, complaint has been lodged by me, Malad.
what is the matter about it otherwise?
Matrimonial dispute, Malad.
Matrimonial dispute?
Yes, ma'am. The bill authority has the power to decide, Malad, plenary power has been given, Malad, has the power to decide everything.
Matrimonial dispute in the
Gallo customary law,
in the husband's clan, she might refuse also.
Malad,
If it is in the if it is called by the husband's clan,
that the right to choose the forum is not only vested with him,
no,
as because
in
it
the
will.
earlier provision, as you said, you yourself has submitted admittedly that there was no provision for proceeding ex parte. Then in that case, what can we do?
That's why, Malad, ex parte provision is such thing when he, Malad, the person is refused. Malad, if say suppose, if person
What is the decision, by the way? What is the decision of the KEBA?
decision of the Kaba is when, Malad, in my favor, Malad,
Okay.
passed in my favor. Against that decision, she prepared an appeal before the civil court, civil judge, senior division, Malad. Senior division has set aside entire things, Malad.
The decision
Saying then, Malad,
decision in your favor, what decision was made?
Malad,
in your
decision,
favor?
divorce has been passed. As per the Galo traditional customary practice, it has been passed, Malad.
Granted.
Granted, Malad. Divorce along with the Malad, the other properties, Malad, what happened? She deserted the petitioner husband and deserted, Malad. In case of such dissertation, as per the Galo traditional customary law, Malad, entire things has to be returned back to the Malad, the husband, Malad, and the properties along with that. This is the customary practice, Malad. So that has been not taken into considerations by the learned court below while Malad, the passing the impugn order, number one, Malad. Number two, Malad, the copy, time and again, someone has been issued to the respondent, but the respondent by written, she refused. When complaint has been lodged, it is me and in my village, the having jurisdiction where from I belong. I have to lodge a complaint before the village authority, village customary court. Now, village customary, as I have pointed out, as per the new civil code act,
No,
2000.
you said it was prior to the amendment of the prior to the amendment of the AFR.
May I take your lordships to the just for a moment?
When, by the way, when it was decided?
Malad.
When
Order was passed on 8 March 2023, Malad.
23 by
By the village customary court. village customary code. And in the month of November, my lord, April, the amendment came, wherein 3 opportunity will be given of that 30 days each, meaning thereby in total that 90 days has to be afforded to them or other party in the event of non-appearance on the part of the respondents within 90 days. First 30 days notice, second 30 days notice, third 30 days notice, and if it still remains absent, fail to appear, then the village customary code has been has been empowered to the past and ex parte order. That is by amendment, that has been given. Now, before amendment, why such ex parte provision has been given in the new Civil Code Act 2021, but that underlying principle is when maybe the other respondents will not be known the proceedings of the such authorities, but when proceedings has been well aware of the proceedings held by the village customary code or the court whosoever may be, then in such case, if such person is refused to appear, then as a court has to pass an order, customary, the non-appearance of the
In the age for the earlier.
just for a moment, may I?
Okay, yes.
Just for a moment, may I clarify this aspect on in the code? AFR, volume 1. Assam Frontier Administration of Justice, Power of the village authorities, Power of the village authorities, section 40, regulation 40, married, 40, 40, civil proceedings, chapter 4, Assam Frontier Administration of Justice, page number 6, if Lordship is having the same book, page number 65, volume 1, page 64, 65, sorry. 40, powers of village, power of authorities, village authorities, page number 65,
65.
or section 40,
40. No, just a minute. Just a minute. Where is it?
maybe Lordship is having a new one,
Maybe.
section 40,
Section
41, 40.
58, different page, yes.
Powers of village authorities. Village authorities shall try all suits without limit of value, There is no, yes, in which both the parties are indigenous to the Union Territory of Arunachal Pradesh and live within their jurisdiction and which are not submitted to the arbitration and under the provisions of the section.
Which one you are reading now? Now which one you are reading?
Section 40, 40.
No, 40 is.
Under Assam Frontier
The
Administration.
village authority shall try all suit without limit.
Yes, ma'am.
Or value.
Yes, ma'am.
In which both the parties are indigenous to the state of Arunachal Pradesh. Finish. That much.
Yes, ma'am.
That much.
And live within their.
No, it's not there. This is different. This is new.
New one, amended.
Lordship, I am sorry to interfere. Actually, this section was deleted by the amendment of 2021.
Yes, ma'am.
Whatever my learned brother is reading, it was already deleted in.
Maybe this one is already amended. To that extent, that is very much clear, The new amendment.
So this is what you say is before amendment of the order in the present case.
Yes,
was passed.
No,
before
no,
amendment.
Amendment was done much earlier, and this decision, the decision is after amendment, But there are 2-3 amendments. Latest amendment of 2023, where the ex parte provision has been given.
But this amendment after 2021 Act, this has been amended, madam. So therefore, rest are not required. Now the only to that extent, the village authority shall try all the suits without limits of the value in which both the parties are indigenous to the union territorial environment. That is the amended the still intact provisions under the Assam Frontier.
Okay, so what to do after 2? We'll continue at 2. Or what?
Yes, other maybe my brother will be
Lordship,
also.
I need time to file affidavit in opposition.
Oh, you have not yet filed.
Not yet. Today is first.
Today you are appearing for the first time.
First time.
What I am praying before your lordship is on the last occasion, the honorable court.
Since they are appearing, let them file.
Yes,
Okay.
in the meantime, may I pray that interim period may be considered,
Now
My
he is
interim-
appearing for the first time.
Yes.
Now since he has appeared, let him file affidavit.
That is the whole thing, Let him file, let him take time as per his convenience. But the interim protection may be granted.
What protection?
Protection by the operation of the imperial order may be state.
Which one? The
Pass with the lallet for below,
Say,
That
civil
will
judge.
suffice the problem, Let him take time, no issue,
Now, how the civil judge order is affecting you, adversely affecting you?
No,
Urgent- Whether it's urgent.
Urgency is, that is the whole thing, by which,
No, the order was passed by the village authority according to you. Village authority granted divorce.
she has,
She has come to your house.
she has, no, she has used entire things. She has used even liquid amount. She has even taken away the other properties. She has even taken. So therefore, that is the urgency, which I am expressing. Let him take time, in the meantime, this the imperial order may be the state.
Your
That is the
Lordship,
whole problem,
This order of civil judge is not affecting the appellant.
No, my lord.
But if it is stayed, Lordship, then it will affect me because this customary court has declared ex parte divorce from my husband.
So are they staying together now?
Yeah, Your Lordship, then they have also decided that I have to hand over all my land, building, car, necklace, and gold, egg money in my account, everything to them. I have been only
As of
left
now,
with clothes.
under whose possession all those properties are?
All the in my possession.
That is the
Everything.
Yes, my lord.
They had the village authority decided to give away my personal property.
Okay.
They have decided that my personal properties, all properties should be given to husband.
Now, maintain status quo then. As of now, status quo.
Yeah, status quo, it can
No,
be.
my lord. By status quo, my lord, they will, what will they will do? My lord, they have taken everything, my lord.
Now,
With
see,
pre-plan,
now-
my lord.
Now, you see, you have to satisfy
My lord.
this court that the Keba can decide ex parte as per the old.
My lord, the amount, whatever
Probably
she required has already been
admitted-
taken.
Admittedly, the Keba doesn't have a power to decide ex parte, it appears. Admittedly, you yourself has submitted that as per the earlier.
No, my lord, my submission is, lordship, my lord, my submission is, it is not, my lord, it is my pleaded case. It is
No,
not.
no, okay, after 2 then, we'll continue at 2, or what? No, let him file affidavit, okay.
My lord, filing of affidavit, I am, my lord, agree, my lord. Let him take time, my lord. How much, how much, my lord, the time he require, my lord, let him take time, my lord. But only thing is that, my lord, the interim period may be considered. On the last occasion, my lord, it is ordered that the next day, returnable date, the interim order will be, period will be considered, my lord.
Lots of fixed date may be given.
Yes, my
So
lord.
that on that day, this interim may be heard.
No, my lord. Again, my lord, the another property which is left with her will be disposed again, my lord. That is the whole thing, my lord. My lord, the last order, my lord, her lordship, my lord, observes that the interim period will be considered on the next returnable date, my lord. Therefore, my lord, this is
The parties are present, we'll consider. Now, add Mr. Engato, line counsel for the appellant. Also, add Mr.
K. Tasso.
K.
Tasso.
Tasso. Okay, Mr. K. Tasso. Learned as it appears on behalf of the how many respondents?
Sole respondent,
Okay.
sole.
appears on behalf of the sole respondent and prays for some time to file affidavit.
Malad, even
Enough for this.
appeal, Malad, such affidavit is not required, Malad.
Just a minute, this is second appeal.
Yes, Malad.
Affidavit may not be required.
Yes, Malad.
Would appear, okay. Tara. This is an application filed under section 100 of the Code of Civil Procedure. Read with section, within bracket as amended, bracket close. Read with section 151 of the Code of Civil Procedure. Against the impugn judgment and order dated 1/5/2025 passed by the Learned Civil Judge. Senior or junior division?
Senior division.
Senior division, Alo, in civil appeal number 7/2023, by which the impugned decision dated 8/3/2023 passed by the Keba, which Keba?
Kugi Pomse village, man.
Hmm?
Kugi Pomse village
Kui
authority.
Pongse village,
Kugi Pomse village.
by which the Keba decision passed by the Kui Pongse village has been set aside
Malad.
on the ground that the said customary court doesn't have the jurisdiction. And nor there is any provision of ex parte proceeding under the regulation under the AFR 1945. Para. Whether records need to be called?
Yes,
for?
ma'am.
Okay, call for the relevant records, we call for the trial court record. And also the customary court's record also would be available before the.
Yes,
civil
that
judge.
might be, that was produced before the customary
Okay,
court.
call-
Also,
It will be-
Learned court.
Call for the trial court record. It would be a scanned copy or the original?
No, Malad, original will be.
Okay, call for the trial court record.
Since it is disposed matter, man.
This matter. After 3 weeks, 4 weeks,
2 weeks, man.
after 2 weeks, after. 3
Subject to
weeks.
convenience on the
After
part of
3
the other
weeks.
party. Lordship,
Para, pending further consideration and until the next date of listing, from the parties are directed to maintain status quo as on today with regards to the subject matter of the dispute.
Malad,
And-
by that way, Malad, everything will be again.
And no further steps or further proceedings.
Malad, may I just phrase, Malad?
Shall be undertaken by either party pursuant to the impugned judgment date.
First May 2025, Malad.
1/5/2025, and this one also. Keba. And pursuant to the judgment and order dated 8/3/2023, and the judgment pursuant to the judgment of the customary court dated 8/3/2023, and the judgment and order of the order dated passed by the civil judge is
3rd March.
1/5/2025, passed by the Learned Civil Judge Senior Division. Alo.
Malad.
Okay. List this matter after 3 weeks.
Well,
Lordship, I will file reply affidavit Or
No, the record has been called for.
yes,
Okay,
development.
rest will take up after two. Continue at two. Yes. Yes, my lord, you have not yet filed. You are representing respondent,
Responded in item number 19 only, Lordship.
19 only.
Yes, Lordship.
18, who is for the respondent? Wakalat number not yet filed. Someone appeared earlier.
No one is appeared.
No one appeared. No, have you taken steps? Whether
Yes,
notice has reached to them?
yes, yes, my lord.
You have for respondent number?
I have all the respondents, Lordship.
Okay, all the respondents.
In item number 19, Lordship.
Okay, 19. So who is in 18? Whether record was called for in this is I. Who is for what? What is this IA for?
For the new condition.
Condonation.
Yes.
of relief. But then the respondent is not appearing.
Yes, but no, no.
How many respondents are there?
My lord, three respondent.
In item number 18, there are 4 respondents, Lordship. And item number 19, there are 3 respondents.
Okay. 4 respondents, none of them are appearing.
Yes, my lord.
So what to do? You take press steps?
Yes, to Dusty.
Dusty service by.
My lord, earlier Dusty as well, same as well process have been taken.
Let me take Lordship to address these steps in respect of item number 18, Lordship.
So you are not the respondent in item 18.
Yes, Lordship.
How it is possible?
I'm
Yes,
only-
I have for delay, condonation of delay in item in CRP, CRP. Just a minute. Who are the respondent in item 19? This is condonation. IA is in the same. How it is possible that you are responded in the civil division? Headmaster, same. You are
Sir.
representing? In item 19, representing?
Item 19 only.
Hmm?
I'm representing item 19 only also.
19 for respondents?
Respondents.
All the
All the
respondents.
respondents.
So they are. This is 19. See, this is 19. This is 18. That means you are representing headmaster.
All the respondents. Lordship.
Okay, all the respondents, including kindly name one.
Sri Rekar Tato. Respondent number 1, Sri Rekar.
Rekar Tato. He is not in 18. Okay. Headmaster.
Headmaster.
Headmaster is in the 19 also, 18 also.
And respondent number 3 is Ngomba Tato.
Mohammed Tato is also respondent here in the 18.
But we have not received any instructions regarding this item number 18.
No, this is for this, I think.
Yes, sir.
CRP and this is continuation for filing this petition
Yes,
only.
and even I did not receive any IA of the copy. And
Now, automatically, you see, if you are representing in CRP, this continuation petition is for filing of the CRP only.
then Lordship, I may be given some time to take instructions, Lordship.
Yes. Because same party.
Yes, sir.
Except of course one. What is his name?
Monu Tato.
No, Monu Tato, yes. Except for Monu Tato.
And
Rest of them-
Rengom Tato. Rengom Tato also, Lordship.
Rengom Tato also. Headmaster and
Ngomba Tato.
okay. Are same. Okay, you obtain instruction.
Yes, sir.
Because this is for filing. This is against the Keba decision.
Yes, sir.
29. It's same, you obtain instruction. Okay. Mr.
N. Kargamalo,
Clerk Counsel for the petitioner is present. Mr.
Dilona
Clerk Counsel.
for the respondent in item number
All
9.
the respondent, all the respondent in item 19 and item.
CRP 31.
Okay, in CRP 31 AP 2022. Submitted. Some of the parties in the IA, some of the respondent parties, IA, to whom he represented in CRP 31 AP 2022 are same parties. Therefore, he may, he submits that he may be allowed to obtain necessary instruction whether to represent the respondents in the IA or not. IA, okay.
Previous.
my lord, in item 19, there is an interim that may be continued.
What is this again? It's 26. CRP 26.
31. In 31.
No, CRP 26 is also there. 26 is here in this case. Okay. Just a minute, huh? This IA is seems different. For not for the 31. I'm going to headmaster, same only. Same. See. CRP 26. The party name, it's all the same. Rangam Tato, headmaster, Nimba Tato, Monu Tato, exactly same. So that means you are representing here also.
No, Lordship. I am representing only Ngomba Tato and Monu Tato.
Okay. Ngomba Tato and Monu Tato.
Sorry,
Okay.
sorry. Headmaster and Ngomba Tato.
Headmaster, see, they are party here also.
Yes, yes.
Hmm. The prayer is allowed. This matter after 3 weeks.
3 weeks. Obliged.
Service report to the respondent number 1 is still awaiting.
Sir, I'm appearing for respondent number 1. This morning I filed wakalatnama for respondent number 1.
You are
Oking
for respondent number
hearing.
1.
Yes.
How many respondents are there?
5 respondents.
5. So.
I'm
what
only
about
for
the
res-
others?
2 to 5 already filed their reply also.
Respondent number 2, 3. So, council already put appeared on behalf of respondent number 2, 3, 4, and 5.
Yes, not affair, but they file our number and file their reply.
No.
Lordship, in this case, need to 1 week's time to file affidavit in opposition.
Okay. Mr.
Omori.
Omori, now counsel for the petitioners. There are more than one petitioner.
Yes, 5 petitioners.
Okay,
2
petitioner.
petitioners, 2 petitioners.
He is present. Mr.
B. Kamdak.
B. Kamdan. Lanit counsel could appear on behalf of the respondent number 1 by filing wakalatnama this morning.
This morning.
Okay. And prays for
1 week's time, sometime to file
sometime to
file affidavit in opposition.
sometime to go through the petition and to response if any, and to file response if any. Stop. No one appears on behalf of the respondent number 2, 3, and 4. Sorry, 2, 3, 4, and 5. Who appeared there? Although
1 N Melon.
their name has been reflected,
Yes, reflected in the workload number, post list.
item 20.
Yes, agree.
Okay. Although the name of the advocate, Mr. Nampu Melon, has been reflected in the course type. Stop. As prayed for by the land council for the responding number 1. Let this matter be listed after 3 weeks.
My lord, there is a interim order that
Yes,
may be
sir.
continued till further order.
The interim order passed earlier. So continue till the next date of listing. Okay.
50 hours.
May I please, your lordship? First, this is civil revision petition against the impugned order passed by the Malad, the Inter-Territorial Customary Court, Malad. There is no Malad, the Inter-Territorial Customary Court, a judge notified, but there is no Inter-Territorial Customary Court is notified by the Malad, the district administration and the state government, Malad. Malad, what happened? If Malad, there is a provisions for the territorial Malad, the inter-customary territorial customary court Malad. That has to be duly notified by the state government as because this is a act, this is defined under.
We have a customary court, sorry.
Customary court is Malad, clear Malad. I think customary court has been governed by the Malad, the village authorities appointed under regulation 5 of the Assam Frontier Administration on Justice Regulation 1945. And Malad, the territorial customary court, who will be the Malad, the members of the territorial customary court? That
They
is
said
not
that
the
territorial
customary court, Malad. That has to be
covering, according to them, covering what?
Malad.
Territorial customary court is covering how many districts, how many?
It is like
Village.
Malad, earlier in a Bango level system, Malad. If
in which tribe? They said
if the decision has been rendered by the Malad, the village authorities, that has to be Malad.
the decision in this case was rendered by which village authority?
Village
Of which district?
Of West Siang district, Malad.
West Siang.
West Siang district.
So
Malad.
they say that they are.
There is a Malad one Malad called Malad, if I use the Malad translated copy,
section, page number 45. Page number 45 of civil revision petition, my lord.
Territorial.
Inter-village,
Territorial.
inter-village territorial customary code of Ubu Bango.
Yes, Bango Keba.
Yes, my lord. It is something like Bango. Earlier it was Bango level system, my lord.
They have
But
given
it has been discontinued, my lord, by author of this honorable court. My lord.
they
And
have
new provision has been
nomenclature.
incorporated in the Civil Act 2021. But however, my lord, who will be the presiding judge? Who will be the members of that Bengal Interterritorial Customary Court? That has not been yet notified, my lord. But
By filing this CRP, you have challenged.
yes,
Which one? Which order of?
this
this
impugn
territory?
order, fourth,
Or the whether?
my lord,
Okay, CRP.
I'm sorry, my lord, or the impugn order is page number 50, my lord, 49, my lord. It starts from page number 49 and translated copy is page number 53, my lord.
Decided against you.
Against me, my lord.
Okay.
Whereas there is
If
no,
it is a decision. Okay, then you have filed by way of.
my lord, basically on two grounds we are challenging. Firstly, my lord, the meeting was of course conducted on 9th, my lord, as per the my lord, notification issued by the my lord, the
You have participated.
no meeting we have participated on which
This was not a territorial.
my lord, in territorial customary code we objected that no, there is no territorial customary code. No notification has been issued. We participated.
Authority was consists of whom? Members.
Members, my lord, as per the impugn order, altogether, my lord,
Of two villages. More than.
yes, of more, same village, my lord. We are from the same village. They are my own family members. My lord, this will.
Anyway, have you taken steps? Upon
Yes,
the
my lord,
respondent?
taken steps.
Are they appearing? No.
No, my lord. As per the record, my lord, the service report is still awaited, my lord.
Okay.
Till
Mr.
such time, my lord, but my lord, in the last occasion also, my lord, in this matter, my lord, his lordship is of the view that he is not well aware of the, my lord, the customary court rules. So therefore, my lord, the order was to be passed on the interim period will be considered on the next returnable date. My lord, what I'm praying before your lordship is till such time, my lord, the impugn order may be, my lord, suspended, my lord. But there is no clear case that members has been constituted. Even district administration has not constituted, my lord. Who authorized them to, my lord, conduct the kaba against the, my lord, the decision of the village authorities, my lord. Village authority is fine, my lord. And the village authority is, my lord, as per the Assam Frontier, my lord. Assam Frontier Administration of Justice. But territorial customary code, my lord, who will be the member, who will presiding over the, my lord, the proceeding? It is not clearly defined, man. Of course, my lord, the territorial customary code has been given in the 2021 Act. So therefore, this is my lord,
Yourself said it's a Bango Keba.
yes, ma'am.
Bango Keba is.
There is no Bango system,
Appellate
ma'am.
authority for the village customary court.
Yes, ma'am.
Okay, then.
They
have
mixed
a
up the entire
jurisdiction.
thing, ma'am.
Then they have a jurisdiction, if it is a Bango Keba.
My lord,
If
there is
a
no Bango
provision-
Keba system.
The provision
Yes.
provided.
And another, my lord, ground is
What is your case, you said? It was initially, who lodged complaint?
Malad,
Before the village-
initially, complaint was lodged before the village authorities, Malad.
By,
It
By
was
whom?
dispute between the cousin brother, Malad. The complaint was lodged before the Malad, Annexure 1
by whom?
by me, Malad.
Before the.
I
village
lodged the
authority.
complaint before
By-
the, Malad, the
before
filed a
the-
complaint before the village authorities. Accordingly, someone was issued.
Okay.
And accordingly, Malad, they participated and this decision was passed, Malad, by the village authorities in my favor, Malad.
Okay.
Against that decision passed by the Malad, the village authorities, they prepared an appeal before the Malad inter-village territorial customary court.
Bango Kebab.
Bango level, Malad. Bango level, as per the in Gumjumango case, Malad, there is no Bango level keba. By this honorable court has held that Bango level keba system is known as in law, Malad. And after that, Malad, there has been discontinued, Malad. It was not factories, Malad. Bango level system.
Decision was regarding what? Or complaint was regarding what?
Land dispute, Malad.
Land dispute.
Land dispute.
Okay,
The subject matter of the
see that-
dispute is
let us see the impugn
land
order.
dispute case, Malad.
Where is the impugn order?
Malad, it is in.
Translated copy.
Yes, Malad. It is, Malad, in Annexure 2, Malad. Page number 21. Type copy is page number 22, Malad.
The original is
Original complaint, Malad. First complaint 22/6/2022. And no, Malad, decision was passed.
no. What is, this complaint is the page 22 is
Page 22 is my first complaint, Malad.
first complaint. Okay.
Yes, ma'am.
Where is the decision?
And the second complaint is, present complaint is page number.
No, where is the decision
Decision is, Malad,
of the in which it was decided
Malad.
in your favor. Where?
Page number 33, annexure 8, Malad. Translated copy is, Malad, it is your own Galo language, Malad. Page translated copy is page number 36, Malad.
Okay. So
Against this Kaba decision, Malad,
Hmm.
they prepared an appeal before the inter Malad HGB Bango Secretary, Malad. Annexure 9,
page
39, Malad. Translated copy is at page number 40, Malad. Appeal against the decision of village level Kaba of.
the opposite party is Tumli.
Yes, ma'am.
Appeal against the head DB Bango Secretary.
Yes, ma'am. Accordingly, Malad, Parwana was issued. Next page, Malad, page number 41. Page number 42 is the translated copy, Malad. Fixing the next date of hearing on 29. Kindly, Malad, take note of this date. 29 May, page number 42, I am reading, Malad. Last paragraph. Therefore, the Bango level KBI is fixed on 29 May 2025, 8 a.m. Malad. For re-examinations of the case at Nikte Community Hall, all the members are requested to take out time and attend the KEBA for amicable settlements of the case, Malad. And KEBA members, they have given, Malad. This is the one of the disputed facts, Malad, who has authorized them to, Malad, to conduct the KEBA, Malad. It is not yet notified. It is not yet notified by the state government, Malad. Even the district administration has also not notified, Malad. Who will be the member of the, Malad? This inter-village territorial customary court. Accordingly, Malad, meeting was conducted on 29 May 2025. But no decision was taken, Malad. On which date? Then re-summon was issued, Malad. Page number 44, Malad. Re-summon was issued, Malad. Re-parwana, Malad. they used the word parwana malam.
Issued against you.
No malam for kaba malam for press malam hearing malam.
Page 40.
Page number 44. Translated copy is page number 45 malam.
It's a re-parwana only.
Re-parwana malam.
Okay. Second parwana.
Yes, malam. Second parwana. Malam first parwana on first meeting, no decision was taken, malam. Of course, the malam members were decided in my favor, malam. Majority of the Keba members decided in my favor, malam. However, malam decision was not taken, malam, on 29.
Okay.
Yes.
Then
malam accordingly, on 4th June 2025, this re-parwana was issued, fixing the next date of hearing on malam 9th June 2025, malam, just below malam, third paragraph. Therefore, to take a final decisions of the matter, a re-hearing page, I am reading malam, page number 45, malam, translated copy. Page number 45. Malam. Therefore, to take a final decisions of the matter, a re-hearing dated is hereby fixed. All the Keba members requested below are requested to attend the Keba hearing on dated 9th June 2025 at 8 a.m. at so-and-so village, malam. And all the members are requested to be present in the hearing without any fail. 3 new members, Keba members are hereby added. The case owners are directed to make their statement in the Keba and may present their evidence and witnesses if any, malam. Altogether, my lord, 15 members were called, and additional Keba members were also added. 3 additional members, malam. Lordship has seen that Keba fixed date is 9th June 2025. But my lord, impugn order, my lord.
Page.
I objected, my lord, the second Keba, my lord. Page number 47 is the, my lord. Page number 47 is my objection, my lord.
Said to be present in the hearing without any fail. 3 new members are hereby added.
And all added members are, my lord, are not from my side, madam.
So the Keba members, 15 Keba members, not
Yes, ma'am.
these Keba members are from the earlier Keba member.
Yes, yes, my lord.
Were they also a Keba member in the earlier decision?
No,
Okay.
3 additional members were not the earlier Keba members, madam.
Okay. So where is the improvement?
My lord, thereafter, my lord, I made a representation before the chairman, the Inter-Village Territorial Customary Court, Ubu Bangko, my lord. Page number 47. This is the, my lord, my objection, my lord. But still, then Keba were conducted. Despite this representation also, my lord.
So you have also acknowledged that there is inter-village territorial customary court.
Since they use the word, they are villagers, they don't know about the such wording. And
so now you object that there is no inter-village territorial customary.
yes, ma'am. Thereafter, my lord, impugn decision has been passed. This impugn decision is backdated, my lord, the impugn, my lord, the Keba decision, my lord. Lordship will find it, page number 53, translated copy, my lord. Page number 53, my lord. Inter-village, my lord, heading is Inter-Village Territorial Customary Court or Apex Court, my lord. Page number 53, I am reading, my lord. Decision copy, my lord. Merit, my lord. First line, my lord. A Keba was conducted on 29 May 2025, my lord. Whereas, my lord, the hearing to be done on 9 June 2025, my lord. Under the chair and umpireship of Toga Mori, the head Gao Bura, Bango Gao Bura, secretary regarding the distribution of the properties between the Tumli Mai and repay my malad. Malad, on 29, no decision was taken, for which the hearing was fixed on 9. But on 9, malad, no decision was taken, but this decision is of 29 May 2025, malad. Whereas as per the read that fixed.
What is the decision?
Decision is malad went against me, malad.
So the Seva order passed earlier.
Has been,
set aside.
yes, man. Without having jurisdiction, man. This inter-village territorial customary code has no jurisdiction at all, madam. So therefore, madam, at this stage, madam, for the interest of justice, madam, just
Have you taken steps upon?
Yes, madam. I've taken, madam.
Mr. M. Kato, Land Council for the petitioner. Although, okay. The office notes dated 22/7/2025 reflect that the service upon the respondent number 1 and 2 is still available. Whether record need to be called for here? Records need to be called for.
No, the record may not be required because we are basically challenging the authorities of the Pango level system, madam. This is only law point.
Now,
madam.
supposing if these
We are on law point, madam.
territorial CAPA,
Madam, if village authority has been duly conferred with such jurisdiction, madam, we don't have any objection, madam. But then, madam, as of now,
that is in your favor.
madam, even that will be not
Decided
available in
in
the
your
record.
favor.
Only that, madam, law point
But
is to be taken into consideration. Madam, the court without having jurisdiction and passed by the such decision, passed such decision, have no, madam, any enforceable order.
They are brothers.
Yes, madam. Clan, own cousin brother.
Where have you stated that there is no authority called village territorial customary code?
Page number, madam, 12.
Your impugn order is at 53.
Page number 53, madam.
Okay. Where have you stated? You said, Sarah?
Page number, it starts from page number 11. Page number 12. Ground 3, madam. Last person, my lord.
Last person, where?
Who, Moli, Keba umpire, my lord.
Yes, only that much.
He is the umpire of the, my lord, page number 53, my lord, which I have read out, my lord.
Where? No.
Now, Bura,
Challenge.
secretary, regard, my lord,
Because your contention is that secretary of Ubu Bango Nikte Circle West Siang doesn't have a
they're using
jurisdiction.
some.
Where is in the impugn order? Where is that Ubu Bango Nikte Circle?
Malad,
Secretary.
It is the authority who has passed this order, Malad.
No, where is it? The authority is only someone else.
Malad,
Who Moli Keba umpire?
Malad, page number, Malad, 44, Malad.
No. From the impugn order, you kindly show the authority who has passed
Malad,
order.
admittedly, they have
So
not
that's mentioned in the order.
Malad, specifically, they have not mentioned, Malad, just only their designation, Malad. Their designation only, Malad.
He is a Keba umpire or whom only Keba umpire? HGB.
HGB is the umpire, Malad, conducted the Kaba, Malad, Bango level system.
That is why.
Therefore,
why
Malad,
I mentioned this. It was passed by Bango Secretary of Ubu Bango Nikte, and then you said that he has no jurisdiction. So now I need to mention the authority who has passed, and then your allegation that that authority has no power. Kindly come to page 12. Page 12.
Malad, firstly, may I take your lordships to the page number 44, who has issued Parvana. This is the same authority who has passed the order, Malad. Parvana, Malad.
No,
Inter-village
don't go to Parvana. Now concerned with the impugn order who has passed?
Keba umpire.
You said that you are not challenging.
Malad, in general,
you are not agreed by the Parvana. Forget about Parvana. In the impugn order.
By virtue of this, Malad, this is the Malad by which Malad decision has been initiated, Malad.
Now, who has decided? Finally, who has decided?
Finally decided by the Inter-Village Territorial Customary Code of Ubu Bango, Malad.
Where is the? Just show me that.
Malad, page number 12. Para.
Oh, no. Please.
Malad, they are using
only one question, huh? Don't go anywhere.
Malad, they are using
only one question. Please listen. In the who passed the impugn order?
Malad, therefore, I am pointing out that as
kindly show from the impugn order who has passed the impugn order.
Malad, it is very much clear in the order itself.
Where?
Malad, here GB, it is in the first line. First line, the umpireship of Sri Toga Mori, head Gaumbura, Bango Gaumbura, secretary Malad.
Okay, that was passed. But then here in the body, you have challenged that it was passed by
Malad,
you have not said that this head Gambura doesn't have a power in authority.
Malad,
you only says that secretary, Bango secretary of Ubu
Malad may kindly appreciate one thing. He is the Malad, umpireship of the entire village territorial customary code. Even if decision is rendered by the village authorities, Malad, admittedly.
Okay. I failed to ask the proper question to you, it appears.
Admittedly, they are using Malad, somewhere they are using Bango level, somewhere customary code. In the heading, they are using customary code. But in the Malad decision copy, they are using Bango secretary. Malad, these are the Malad, therefore Malad, there is no jurisdiction, Malad. Even Bango system, Bango level, or the inter-village territory customary code.
Now, and I cannot combine everything and say that he doesn't have. You somewhere you said that this Ubu Bango, the secretary of Ubu Bango Nikte Circle, West Siang District AP, does not have the jurisdiction. This is the only statement where you have given that he has no jurisdiction. And the authority is not the same one who has passed the impugn order. That is why I'm saying.
No, Malad, this is same authority, Malad. Of course, they are not using.
Show me that one.
They are not using Malad entire thing.
So that is why. How do we use the silent?
Impugn order, Malad, just मतलब मैं pray that मतलब impugn order देते 29 annexure मतलब annexure only annexure 13 मतलब
Impugn order is 29.
yes मतलब page number sorry page number 49 मतलब I am challenging this order मतलब whosoever may be the authority मतलब
Okay, where in the body of your, where have you stated that this authority, the inter-village territorial customary court doesn't have the jurisdiction? Where have you stated in your, in the body of your petition?
page number 12 मतलब
Yes, where?
para ground floor मतलब
Okay. Can you read it?
मतलब for then the Bango secretary of Ubu Bango
Yes.
Nikta
You said
circle
Ububang, but
yes
the person who passed this,
now
there is not the Ububango.
madam West Siang district AP does not have jurisdictions to try and issue parwana and pass such decision in as much as the government of Arunachal Pradesh has not notified the inter-village customary code.
Now you clarify where is the Ububango in the
Malad,
impugn order?
I'm sorry, Malad, if they are not mentioning the word, Malad, such word.
No, if they have not mentioned, why should you mention?
Malad, this is the only Malad, the decision from the decision of the village authority. Malad, this impugn order, Malad.
Where is the
Malad, I cannot insist them to Malad mentions the particular word. But what I'm challenging is this impugn order, Malad, page number 49.
The impugn order was passed by whom? You have to mention the impugn order passed by whom?
Signature by the Malad.
Why you should mention the some other authority?
Malad, kindly appreciate decision. This is the decisions of the inter-village customary code, Malad, not individual Malad. But individual under the umpireship, the person who umpire the Malad, the proceeding has given their own name, Malad. My lord may kindly appreciate one thing. In the heading, they have given the this customary code, the body of the Malad, the code. And in the person who has presided over.
Very difficult.
Malad may kindly appreciate this page number 53. This is the Malad, the heading.
From the page number 53 in page number 53, 54, 55 is the
impugn order.
Okay. From here, you kindly show me, my simple question is,
Malad,
where is the Bango secretary of Ubu Bango Nikte Circle?
Malad,
Because you have challenged that order.
Malad,
And you say that person, that this authority doesn't have the jurisdiction. You don't say, you never say that this HGB Keva umpire.
Kava umpire is the authority, Malad, who
doesn't
umpire,
you did not
umpire the Malad proceedings, Malad.
Hmm.
But this is the impugn decision of the village authorities umpired by one Malad GB Malad.
We cannot mention some other authority. I need to mention the
then in that case,
Malad passed by.
Malad,
Passed by. Who passed? And then you have mentioned somebody else which is not in the order.
Malad, I'm time and again, Malad, making my submission. This is the village inter-village customary court authority and the so-called Malad, the Bango secretary, Malad, headed by the head GB of the Bango Malad.
Okay.
And he has given his name, Malad. But this is a forum, Malad. This is a body, Malad. This is an institution, Malad. This is a court.
Impugn or passed by the inter-village territorial customary code or effects code headed by the umpire does not have the jurisdiction to try does not have the jurisdiction to try and decide the appeal. Or they are not authorized to decide, and authorized to try and decide the appeal under the have you said that they are not authorized under the Civil Code Act? Have you said?
Arunachal Pradesh Civil Code Act 2021, man.
Hmm?
Yes, man.
Where? Hmm? Under the Arunachal Pradesh Civil Code Act. Where have you mentioned?
Malad, page number 12. Malad.
Okay, well, Tara. There's no power in our jurisdiction to try and decide the appeal, huh? Is they are not the inter-village customary court under the Arunachal Pradesh Civil Code Act. Okay. That is also not the LPPS.
Admitted.
But then.
That part is also.
You have taken step by Dusty Service?
Malad, Dusty Service is there.
No.
Dusty Service,
But
yes,
last
I'll try, man.
last order, you were asked to, you were directed to take steps to effect the notice upon the respondent by through Dusty mode.
Yes.
Hmm?
Along with Dusty, Malad, usual course, man.
Have you taken steps?
That part, Malad, they are Malad, not in a position
No,
to receive the.
then how do we pass interim unless you effect the notice upon the respondent?
Malad, the steps were taken.
But Dusty, by way of Dusty mode.
Malad, the impact we have taken, but they are not in talking terms, Malad. So receiving of the copy is again, Malad, another difficulty.
No, it can be Dusty mode. Then why you have made a prayer?
Malad, it was actually not my prayer.
Hmm?
It was admittedly, Malad, not my prayer, Malad. Malad, this is taking Dusty Service is not conducive, Malad.
See, unless the notice reaches to them and in the initial, no interim was granted.
But Malad, steps were taken, Malad. Usual steps, Malad, usual course steps was taken.
The notice was issued to the respondent. However, by way of register post with AD, however, the petitioner has not taken steps upon the respondent by way of Dusty mode. The petitioner shall take steps upon the respondents by way of Dusty mode and file affidavit Dusty to be routed through the registry of this court and file affidavit to that effect. So this matter again after 4 weeks. So in the meantime, it is provided that the impugn Keba decision dated. Impugn
29, my lord.
decision
29 May 2020.
decision dated 29/5/2025. The impugn order, huh? Impugn Keba order. This is a decision or the decision? The impugn Keba
Decision, my lord. Keba decision.
dated 29/5/2025. Issued by the Inter-Village Territorial Customary Court, stroke Apex Court. Shall remain state. On the operation of the impugn, those customary court shall remain state till the next date, remain state. Okay.
Madam, deeply obliged.
But the authority you have mentioned is different from the authority.
Admittedly, madam.
Authority or the order passed by the Keba. You have, I think, to clarify.
In practical, my lord, what I have seen.
Practical, because this order is,
Yes.
there is a specific order passed by the
Yes,
Keba.
madam. Sure,
And
madam.
there is authority specific.
Sure, madam.
Authority they have mentioned what they are. So that is to be mentioned, not the one which you know actually.
True, madam.
Yeah. The one
Madam,
which they have.
This Keba village, Malad village authorities, Bango level system, inter-territorial, all these are made by the Malad the villagers, Malad.
Your knowledge will not do here because they have passed it. When you challenge the particular order, you cannot just bring it import from anywhere. You have to mention the authority who have passed.
True, Malad.
Okay.
But they are simply using that terms only, Malad. But that's much of it.
Your Lordship, in this petition, the petitioners are seeking protection of their land. Through this petition, the petitioners are seeking protection of their land from the construction activity by the respondent department. The petitioners in this case, they are land.
Just a minute. Why it has in this case? Unserved notice must be respondent when I am having received that and still awaited. You are for?
I am for RWD.
Okay.
This
But
is
who is this respondent number 8?
They are private
Private-
respondents.
8, 9.
Yes, private respondents.
Private respondent. Have you taken steps?
Yes, I have taken steps.
I am for 1 to 7. My lord, otherwise also this writ petition is not all maintainable, not like to be issued, not even notice also.
Okay.
There are 7 of the writ petition. Page 13.
What is there?
Petitioner himself admitted that petitioner number
Para?
11 of the writ petition.
Okay.
They have already filed PI for same set of issues.
Oh, that the petitioner number 1 has filed prefer a PI in the
Yes.
respect of the same issue.
Same issue.
That is a different.
And it
video.
was dismissed by the division bench of this honorable court.
Your Honor, the issue is same, but the ground is different. In that case, there are because Your Lordship, in that case, there is only one
What do you
petition.
mean?
Now,
This is funny.
The ground,
now we improve with bringing 4 more petitioners here in this case.
no, Your Lordship,
Issue is same, but the ground is different.
yes, I mean the same NIT.
The person is same, but name he has taken a
Even the
different
person,
name now.
even the persons are different now. Because in that case, Your Lordship, there is only one petitioner, and the ground taken was that the misuse of.
No, that is it.
Even all the issues, ground is all same. There are 7, he has set out the ground on which he has filed this writ petition.
Now, how that can be?
Because Your Lordship, in that PIL,
Mr. X committed offense Okay, now he has taken a name as Mr. Y. Now you said it was Mr. X.
No, because
Me,
your
Mr. X,
your lordship,
Mr. X. You can't
here there are 5 petitioners in this case. Here there are 5 petitioners in this case.
5.
Yes, in this case.
In this petition?
Yes, in this petition.
Okay.
And in that PL, there is only 1 petitioner.
How many?
Only 1.
Okay, so that one is also here.
Yes, 1 is also here. But
Okay.
here we are seeking protection of our land. That PIL was on a different footing, saying that the public fund is being misused. That was the issue in that case. But in this case, we are seeking protection of our land from illegal activity without the consent of the landowners. That is the case here today.
In that case, what?
The misuse of the public fund. Misuse of public fund.
For public fund?
Yes, that was the issue in the PIL.
Okay.
But the issue today that we have, the petitioners have filed today is that the illegal activity without consent of the landowners. Because you see, for the PMGSY road, they have to obtain consent of the landowners. There has to be an affidavit saying that we have donated the land. And they have to say the certificate of land availability, which is not been.
Issue itself is different there.
Yes. The same NIT, but different issue. So it is very much maintainable in this case, Your Lordship.
Same
NIT, but
NIT?
yes. NIT is same.
What
but-
NIT?
Your Lordship. We are
There is
challenging.
also NIT here, involved here.
Yes, we are challenging the same NIT. It was challenged in the PIL.
PIL also.
Yes, yes.
Same NIT, you have
Yes.
challenged there also.
Yes, but the issue is different.
Then it's same only.
That is
My
your-
lord may read
Because the
para
challenge-
7.
Challenge on that against the NIT.
NIT, but
Then you see, if it is different, not by way of filing. If you are, now you are alleging what?
the protection of our land. Means they are constructing activity in our land without our consent. That is the issue here today.
That means encroaching.
It should be encroaching only, Your Lordship, because
Then criminal, you file FIR.
that has already been done, but
Then what happened to that FIR?
it is just pending without any action.
So now then you
Therefore, Your
file
Lordship,
PIL, dismiss, file FIR.
the FIR was filed.
Now this.
No, Your
There is
Lordship,
3 cases for one thing then.
the FIR was filed before the PIL. The FIR that was filed before the PIL, because we are
Then
alleging.
FIR has to be pursued then. Has it been registered?
Yeah, that also I have mentioned, Your Lordship, that in the affidavit.
No, probably you have to, first of all, you have to clarify your stand. Your claim also, and then you have to clarify here in this petition itself. What was your claim in the PIL? And if FIR was lodged, for what? Have you pursued or that was not? And are you agreed by non-registration of the FIR? Or not, or against the authority who is not taking any action on your FIR? I think the entire thing has to be revealed in the writ petition.
That I have revealed. Your Lordship.
Certain things, so many things happen, but then you have taken some,
Even as regard to the FIR, Your Lordship,
only few points. Later on, it will come to know.
that is
And
in
you'll-
page para 10 of my petition, Your Lordship, regarding the.
Para 10, what
Yes,
have you said?
regarding the FIR.
Now you have to pursue this FIR then.
Yes, Your Lordship, yeah.
The police is not registering FIR. You file before the SP. Then if SP also refuse, and if the SP also remain or in action, then you file the writ petition for direction to register the case against the department if they are illegally, because you are alleging the criminal action against the department.
Yes, Your Lordship.
So that I think would be proper.
Now
So
you-
by this writ petition, what is your prayer?
that my land may be protected.
No, see, you have written this FIR.
Yes, so
You specify, what is your prayer? Let us see. See, your prayer is NIT, set aside NIT. That must have been in the PIN.
The prayer number 3, Your Lordship. At least the prayer number 3 may be granted. The prayer number 3, point 3 in my prayer. So, so
As
either
of
they
today,
have to.
his prayer is in fractures.
They have
Now, see. Now, if you establish that the land belongs to you, or if they belongs to you, then the police also will act on the FIR, take action against the person who encroached, and then it might so arise that you prove your case that you this land belongs to you. Thereafter only the further action will be initiated. Further claims. Unless you prove that land belongs to you, it will be difficult.
One document is there, Your Lordship, by which I can.
If you are not owner, how do they seek permission from you? You have to prove first your ownership over the land.
Yes, Your Lordship. One document is there, which shows that it is
One
our
document. Then in that case, you have to file title suit. If you say that this land belongs to you, it has to be decided by the trial court.
Therefore, Your Lordship,
If you are disputing the ownership of the land, you say that you are owner. Nobody is recognizing you. Your PL dismissed.
No.
Case not registering. That means you are not the owner. You are not recognized as the owner.
Your Lordship, the manner in which they have approved the sanction, they have given one affidavit.
It will do. That will go only unless you prove yourself your case that you are the owner and they need to take permission from you. Your target is to for compensation or what?
My
main motive of the petitioner number 1, he is interested in the contract work.
See, you have a target or you have target behind, and then how do we understand? And
when
you are
you
filing FIR, filing PIL, and then writ petition, everything you are trying. How do we know that what is your intention?
The intention in this case, Your Lordship.
When he failed to get contract work, then he started all this.
That is not the issue, Your Lordship. Your Lordship, if you look at page number 30, the affidavit of the one of the petitioners, this is the affidavit by which they have, which is one of the mandatory requirements in
the page
30, Your Lordship.
30?
Yeah, of my petition.
Okay, what is this?
This is an affidavit of one of the petitioners, which they have created, the respondent department which they have created. This is one of the requirements in any PMGSO scheme, Your Lordship.
30?
Yes, 30.
Memorandum of understanding.
Yes,
Yes.
they have given the land.
So what I'm trying to show by this page. Your Lordship.
Anyway, just a minute. So since there is a respondent party, there is a who are the respondents? State and
The firm who got the works.
And according to you, what is your submission, by the way?
My lord,
apart from this, this is not maintainable. Apart from that, the land belongs to?
it's a community land. The Blaze Gamburas, they donate the land.
You have
page 30. So there was memorandum on the basis of that, a project proposal was sent to the government of India for construction of Vibrant Blaze Road. This is public interest road only.
Then you file affidavit.
Yeah.
Okay.
Otherwise,
file affidavit that. Then who will examine that also? Since already you say the notice was already
same
issued.
ground.
Notice already issued, and then thereafter also it was listed.
Yes.
For more than once, more than twice, huh? Okay, so okay. Mr. K. Tajadan, counsel for petitioner is present. Mr. G. Tarak, counsel for the respondent.
1 to 7, I think.
1 to 7.
Rural Work Department
is also present. The notice upon the respondent number 8 and 9 is still awaited. If it is a community land, it was already donated by the community, and probably you file petitioner. The community also, if they comes to know, they would also object against you, probably.
Yes.
If there is.
Now work is going on.
Now,
Execution of work is going on.
Okay, work is going on. Okay. In view of the above, let this, you file affidavit.
No.
So because raising this issue also,
Yes.
ingenuity, etc. Okay, in view of the above, let this matter be decided after 3 weeks.
And I'll make it 4 weeks. These days,
4 weeks.
law dating
4 weeks.
takes lot of time.
4 weeks.
2 weeks also, because the work is going on and.
4 weeks.
Awaited, okay,
Now even for other
okay,
matter.
Tarak, for respondent 1 to 6
7.
is also present, who 7 and prays for 4 weeks time to obtain instruction and to file affidavit in opposition. Okay.
Yes. Okay.
May, my lord,
Yes.
I'm for the petitioner. Service to the respondent have been served.
You are Mr.
Solam Tana.
Yes, Tanala counsel for the petitioner is present. Mr. M. Tato, counsel for the respondent number
1, 2, 3, and 6, madam.
1, 2, 3, and 6 is all present. The petitioner has taken steps upon the respondent number 2, 4, 5, 7, 8, 9, and 10. But not yet taken. You have not taken.
Yes, my lord, I have already
You taken
taken the
steps. When?
steps. On the date 1st May 2025.
No. Now 22/7/2025, office note says reflect that step not yet taken upon the respondents. Not yet taken. No. It will amount to wrong submission. In the earlier also, June also, it reflect that you have not taken steps. Then
Yes,
you
my lord.
say, if I record that you have taken steps, and if it founds that you have not taken steps, it will be difficult. You remember first.
Sorry, my lord, fresh step may be allowed to take him.
No, not fresh steps. It's a step you have not taken yet, not yet.
My lord, on
Okay, Mr.
First May.
Esther,
1st May, I have
Mr.
issued the notice.
Tana,
Yes.
Land Council. Submits that inadvertently the step has not yet been taken till that. We press for further 1 more time to take steps upon the respondents. Step upon the respondent number 2, 4, 5, 7, 8, 9, and 10 be taken by a registered post with AD as well as by user process within a week from today. Okay. List this matter after 4 weeks.
Obliged.
Not yet filed. Affidavit in opposition not yet filed. So who represents the respondent? No one.
It was GAT, my lord, the last opposite. In the last opposite, GAT was appearing. It appeared.
Who appeared?
GAT.
For the government?
Yes. There is no private respondents.
Okay. Mr. Deep, from the blind counsel for the petitioner is present. No one appears on behalf of the respondent. Not filed affidavit in opposition. So, in view of the above, The matter stand adjourned. List now adjourned.
Next week, my lord.
List the matter after a week.
Correct.
Yes.
I have taken a step to the party lordship.
Okay.
As per record,
Mr. Tapa.
they are yet to file affidavit because they have
Tapa,
received
Bank
the
Council for the
service of
Business. How many respondents are there?
6, I think. Extra copy I have already furnished to all the parties. And one
State is also one of the respondent here.
the respondent is there.
Yes. Yes. Sangeeta, are you appearing on behalf of the state? Not yet filed affidavit. It appears. Who? Okay. Miss Sangeeta, direct government advocate, appearing on behalf of Mr. S. Tapi. Raised for further 3 weeks' time to file affidavit to obtain instruction and to file affidavit in opposition on behalf of the state respondent. Any other, the private respondent is also there?
No any private respondent.
No, Sri Chera
private
Tapung.
respondent is there. One more private respondent. Sarah Tapung.
Hmm.
Sarah Tapung, I have taken private respondent.
Mr. Tapung, you are for the petitioner?
Yes, I'm for the petitioner.
Come to your place.
I'm for the petitioner.
Why you are encroaching?
I'm for the petitioner. The Sarah Tapung, I have taken steps. They have reported that notice has returned. They have
Notice.
accepted.
You have
Yes.
taken step? Oh,
Yes.
Okay. The office note dated 22/7/2025 reflect that the service upon the respondent number 6.
And all are, and rest of the respondent, government respondents, I have given copy to all the parties. Extra copy also I have furnished.
Okay. Oh, sorry, notice upon the respondent number 6 has been received. No. No, has been closed. Service of notice upon the respondent number 6 has been closed through the Division Magistrate First Class, Division Magistrate First Class Colonial, and which was duly received. However, no one appears on behalf of the
Respondent number 6.
Respondent number 6. So since the state is also seeking some more time,
Yes.
who listed? Get it listed out, okay. There is break for by the state respondent. Let this matter be listed after 3 weeks.
3 weeks.
Yes, Your Worship.
Interim order is there, that may be continued.
The interim order passed earlier shall continue till the next date of this. Okay.
Hello.
Yes. Lordship, this is a part matter. Already I have given full length submission on the part of respondent also.
Part matter?
Not part. Yes. Already submitted, full length submission has been given by the affiliate also. From my side, as I have given.
But it is not part.
Hmm?
That was done, hearing was in fact almost completed.
Hearing was
Lordship
completed.
report.
Reply
But
is
your lordship did not want to take it because it was just prior to the vacation. So it was the part.
Okay.
Hearing was completed on lordship, I am to say. On 26, as per the last order, 26 June, reply was to be given. I have given my submission from the part of respondent side.
Submission
Rep-
was,
Yes, I have given my full length submission.
Yes.
After submission of the petitioner,
no notes.
there must be a note.
But 26 June 2025, reply was to be advanced from the petitioner side. And matter was again fixed today for disposal. Written argument as I have submitted. Whatever this matter about in brief, just to refresh. Petitioner may have since right to begin is always with the petitioner. Because this is a lordship with regard to lordship judgment decree passed by the this civil justice senior division. That is already.
The suit was decreed in my favor, man. Respective. Against that.
By which court?
By the civil justice senior division.
Civil judge senior division of?
Hello.
Okay.
Against that, an appeal was filed before the first appellate court, that is the district judge. That appeal was not accompanied by a decree. I don't may recall now. Was not accompanied by a decree.
Just a minute, sir. No, this not. I think after hearing, at the time of hearing, generally I used to make a small note for note. That is not available.
Maybe it has been misplaced. Otherwise, hearing was done. But it was just came up before the vacation, so your lordship did not want to carry it. Not vacation, just before your lordship went back.
Yes, I remember the party.
Yes.
Just a minute. But the
if it is to be reargued manner, it may be some other day, manner. I will be able to complete.
No. Total re-argument may not be required. But then I need to record.
This is a simple case, man.
Just a minute.
A memorandum appeal can only be filed against a decree.
This is filed by you?
Yes.
Just a minute. So that district in the first appeal,
yes,
before the district judge.
The memorandum of appeal was not accompanied by a decree. The decree was not put to challenge. Which is an incomplete appeal, defective appeal would not have been taken cognizance of. Appeal can be filed only against the decree, not the judgment. The two grounds. The other one is there was delay. No application for condemnation of delay was filed. It goes to the root of the matter.
So no condemnation petition was filed.
Yes. Now how that 2 points were dealt with by the learned first appellate court is at page 126. Now, my learned friend argued on that day why the reason for delay and all. All these are misconceived. I am on second appeal before lordships. The only issue before lordship is whether appeal could have been entertained without the decree being challenged and without there being an application for condonation of delay. Why there was delay by learned friend argued more than 1.5 hours. In my humble submission, it was totally misconceived. That arguments ought to have been advanced before the first appellate court, not before your lordships. At page 130, 126 is the impugned judgment. Impugned judgment starts from 126. The 11th paragraph is at paragraph 5 at 130. How many of the decree not being filed was dealt with by the first appellate court?
130.
130, paragraph 5. Mr. Such and such, learned counsel for the respondent plaintiff, advocated the impugned judgment and decree contending inter alia that this appeal is not maintainable in law as well as facts. He has urged the court to dismiss the appeal at a threshold that is barred by Provincial Limitation Act, opposed the appeal referring to the provisions of section 96 and order 41 that there is no scope of appeal against any judgment inasmuch that the memorandum of appeal in the present petition does not challenge the decree drawn in the contested suit. The reason now. I have carefully perused the records available before this court. It is found that the memorandum of appeal does not mention about the decree. It's an admission. Be that as it may, the defective per se should not be the only reasons to dismiss it. Civil law as such is dynamic and very vast. Oh, the reason panel. All the pleaders are not placed in equal position in terms of accessibility to law journals, books, and exposure to variety of legal branches pertaining to civil disputes. Hence, a liberal view is considered. With greatest respect, how can this be done? The reason is that some advocate may have some better knowledge, some advocate may not have better knowledge.
So the ground taken by you is demolished by this. Okay.
It's unbelievable.
So you are agreed by this.
Yes. How can this, my lord knows, appeal cannot be filed as a matter of right. It is statutory right.
Statutory.
Yes. And my lord, what the Supreme Court has said on the last opinion also, it must be there. I'll just point out, only on this ground it should go. On decree part by Larded Firm did not advance any argument on the last occasion also.
This is
1960 SCC online SC 149.
It is there.
It must be there.
Yes, it is there.
Appeal is not a matter of right. Paragraph 5.
Paragraph 5. Yes.
The position of law under Order 41, Rule 1 is absolutely clear. The position of law under Order 41, Rule 1 is absolutely clear. Under the said rule, every appeal has to be preferred in the form of a memorandum signed by the appellant or his pleader and presented to the court or to such officer as appointed in their behalf. It has to be accompanied by a copy of the decree appeal from and of the judgment on which it is founded. Rule 1 empowers the appellate court to dispense with the filing of judgment. There is no jurisdiction in the appellate court to dispense with the filing of the decree. Where the decree consists of different districts in several directions enforceable against the same or several defendants, The court may permit the filing of such procedural decree as are the subject matter of appeal, but that is the problem with which we are not concerned in the present case. In law, appeal is not so much against the judgment and against the decree. That is why Article 156 of the Limitation Act prescribes a period of 90 days for such appeals and provides that the period commences to run from the date of the decree under appeal. This is important. Therefore, there is no doubt that the requirement that the decree should be filed along with the memo of appeal is mandatory. And in the absence of the decree, the filing of the appeal would be incomplete, defective, and incompetent. Now, my lord, the First Appellate Court derives its powers in a civil case from the CPC, my lord. You cannot take a liberal view. It's a statutory appeal. On this count itself is closed. He is not remediless. File a proper appeal challenging the decree. Limitation part is a paragraph 12 of the judgment.
Page?
Page number 124.
Yes.
Paragraph 12. For the purpose of computing limitation, time period for appeal against a decree is 30 days and limitation runs from the date of decree of the suit. Even the appellate court was saying. Period is it made. The orders recorded on such and such interpretation nowhere indicates any objection having raised the respondent by the respondent plaintiff during the first and subsequent hearings. In the circumstances and under the provision of section of limitation inferred that the delay of 90 days taken in such and such has been condoned. Is inferring. How can that be done? Delay goes to the root of the matter. It was argued on behalf of the respondent here in the Valorant Flag that it is a mere technicality. They don't amount to changing the law later on by the Supreme Court. How can delay be a mere technicality? But I had read up on the judgment of the last occasion, 2008-14 SCC 445. Admittedly, the judgment impugned itself reveals there was no decree filed, decree was not challenged, and there was delay. So it's inferring. How can there be any inference? 2008, volume 14, SCC 445. The first judgment, my lord, the ignorance admission is AIR, AIR. Volume. 2008, 14 SCC. At page number 452.
Yeah.
Paragraph 272, second last page. Paragraph 31, 32, 33.
Okay. Yes.
But even otherwise, according to the council, if the application was not within the period of limitation, the so-called concession would neither bind the bank nor invest jurisdiction or power in the authority to entertain such applications, which is barred by limitation. In other words, according to the council, the concession was against the provision of law which would not bind the bank. Now, limitation goes to the root of the matter. My learned friends, is a technicality. The Supreme Court says something else. If a suit, appeal, or application is barred by limitation, a court or an adjudicating authority has no jurisdiction, power, or authority to entertain such suit, appeal, or application and decide on merits. What can be more clear, man? In 33, subsection 1 of section 3 is read as unders. Where reading of the aforesaid provision leaves no room for doubt that if a suit is instituted, appeal is preferred for application is made after the prescribed period, it has to be dismissed even though no such plea has been raised or defense has been set up, even if no plea has been taken. In other words, even in the absence of such plea by the defendant, respondent, or opponent, the court or authority must dismiss such suit or application if it is satisfied that the suit, appeal, or application is barred by limitation. That's it, my lord. So, simple question.
Yes. Okay. So, may I, Lordship? I think I have heard you.
Yes.
Although I don't remember, but then I have to reply, Lordship.
How can there be a reply to a reply, my lord? Then I will have to reply again.
Okay, yes, short, without going
Okay,
into
answer these two
all those,
questions.
all those facts of the case. Yes,
Lordship,
on-
kindly
on
see,
low point.
substantial question of law.
That
is a wrong submission, Lordship. Kindly
Okay,
see the
that-
order dated 18/12/2021.
Just a minute.
This is a completely
You
misleading
have
statement,
to
Lordship.
delay to clarify.
Order
Delay and
order dated 18/12/2021 of this honorable court, Lordship. What is the substantial question of law? This substantial question of law is required to be argued. Argument should limited only within the substantial question of law. Kindly see, this is there is no degree as such. Degree is not here. Kindly see the order dated record source 8/12/2021.
Just a minute, just a minute. So
As per this,
the issue.
only there is only
substantial question.
substantial question of law. Beyond that, party cannot submit. Beyond that, party cannot submit.
Just a minute. I am aware of this.
My lord will see. The first substantial question of law is whether the first appellate court is rightly allowed the appeal without the memo of appeal not being accompanied by any.
There is no degree is not
Just
challenged.
Just a
Just a
moment.
minute.
And without any condemnation during 90 days and without the degree being enclosed therewith. What is he reading? So easy to say I'm misleading this court. Maybe my English is not good. What is he saying?
Okay, you're confined to.
This only 2 points.
Substantial question of.
Yes, substantial question of.
Okay.
Arguments should confine only these two substantial question of law. Because as I have earlier, after long time, it is this with regard to this condonation delay, I have explained on my previous argument, saying that I would like to this again draw the attention of this honorable court to refresh the memory. Kindly so.
No, just please, this time confined to the
Within this substantial question of
substantial question. of-
yes, only 2 points.
Yes.
Why this question number? I am coming to the condonation of delay. Why this 92 days condonation of delay? Why there is delay has been condoned? That is the issue. What has been submitted? Yes. As per my submission, I have given my argument, written argument. As per my written argument, kindly see. This judgment was never been pronounced in the open court. That is my take on. Kindly see the judgment dated. Kindly see the judgment dated 2020, page number 76 of the appeal. 76 of that.
Now, kindly turn to the page number 78 of the appeal. Date of hearing is 8/12/2017. Judgment is marked. But judgment has been pronounced on 8 January 2018. That has never been notified to the parties. And the court has informed us saying that the judgment has been pronounced. As and when I have received the information from the court, I have applied. Then when I have applied, kindly see.
No, whether this argument you have made before the appellate court.
Exactly, ma'am.
This question.
Kindly see. I have enclosed my petition. Kindly see the same petition. Para number.
These are good grounds before the first appellate court, my lord, not before your lordship, that is.
Very sure. I am submitting also. My written this affidavit in opposition, kindly see. Page number 20.
Affidavit in
paragraph
opposition
number
filed
10.
before, filed before.
Before the appellate court. First appellate court.
Okay.
Not this. Before the first appellate court. Where case was in my paper. Before the district and session judge.
Okay, you have raised it.
Yes.
What is the decision?
That was the, in my paragraph.
So what is the
10,
decision?
paragraph 10, I have made clear.
Okay, you have made clear, but what is
Clear
the?
averment saying that the judgment copy was received on 17/4/2018.
Okay, what is the observation of the then appellate court?
Has
Judgment.
observed as per the observation, as per the observation of the court. May I read my contention before the court. Then I would like to take your lordship, this, as per the paragraph 10, my averment over the condemnation issue. I said, the judgment copy was received on 17 April 2018 from the Court of the Civil Justice Senior Division West Siam District, Alo, Arunachal Pradesh. As such, this appeal is filed within 30 days, which under limitation time, which is under limited. Hence, no limitation does not bar, does not arise. I have said, I have filed a case appeal before within the 30 days. That is why, when I have filed a case within the 30 days, the limitation issue doesn't arise. That was my contention before the court. But this is the observation, kindly see, page number 12. Page number, judgment, para number 12 of the judgment.
Judgment.
Impeach judgment, yes, impeach judgment before this honorable court. But court has observed, my contention is otherwise before the court. Under what circumstances case has been allowed, that is up to the court. For the purpose of computing, may read judgment order page in my page number 41 of my this
134.
affidavit.
134.
Yes. 134 in the this affidavit. Paragraph 12. For the purpose of computing limitation, the period for appeal against a degree is 30 days. And limitation runs from the date of degree of the suit. Be that as it may, the order recorded on 15 May 2018, 20 September 2018 in the Prudential Court nowhere indicates any objection has been raised by the respondents. Never raised there is any limitations issues. Now the limitation is being raised here. That this right has been already waived. Prudential Court indicates that no objection has been raised by the court plaintiff during the first and subsequent hearing on the appeal. In the circumstances under the provision of Section 5 of the Limitation Act, it is inferred 90 days has been taken preparing this has been condoned on oral explanation and before the Prudential Court had passed. Hence, issue number 1 and 2 has been decided in affirmative. This is the observation of the court. My take on the
Just
limitation.
You have filed affidavit in opposition. In
This is para not in para affidavit in opposition. This is in my this